Hey, what's going on, everybody? It is Artie's Corporate Fiction. Happy Friday, all of you. Good to be here. We are now finally in part 3 of this trial. I believe this will be the this is gonna be the last part. I have actually done you guys a solid by going through the preliminary stuff and cutting it down and kind of shrinking it so it's a lot more condensed, so we can get ourselves right to the actual trial itself. So while I have Skyrim already up and running, I likely won't be playing it too much, at least in the beginning, because there's a lot of timestamps and a lot of skips I gotta do. But it's always good to see you guys. Also, I want to thank Doug out there. He sent me another care package. So tonight's drink is a Vienna lager called the Diamond Dog. So shout out to you, Doug. Thank you very much, man. And we're gonna get this show on the road while I move some things here. Yep. So right now we're going to start out at the 16-minute mark because it's a lot of like preliminary. He walks into the building, talks to court staff, yada yada yada.
Thank you, sir. I'll go ahead and get started. I wanted to make sure everybody got in that wanted to get in. And of course, when we take breaks, we'll let other people come in, but I don't want people coming in and out during the hearing because it'll be disruptive. It'll interrupt what we're doing. I'm Judge Franklin. I am the JP over in Rains County, and I'm filling in for Judge Holland. In Wood County, we have a bench exchange agreement, which is what we do when we cover for judges in other counties, especially in smaller counties. We do bench exchange agreements so that we can cover for each other. So I am going to preside over this hearing in Wood County today, sitting in for Judge Holland. We have two bailiffs today, and you're both deputies, I assume, right? Deputy Sepulveda, did I say that right? Sepulveda, okay, I apologize.
Oh, you're fine.
And Deputy McGee. And the Justice Court Clerk is Ms. Ricks, who's seated to my right. The other chair to my left is the witness stand. So any witnesses that are called will testify from the witness stand. Okay. Today we're here for the case of the state of Texas versus Mr. Now that you're here for your trial today, I want to make sure you understand your rights. Okay. First, you do not have to say or do anything. You may choose to make arguments, ask questions of witnesses, and present evidence.
Well, Your Honor, I think this court's not ready for a trial.
Let me
I understand you drove all the way over here, but the court has not acquired jurisdiction yet, and can't.
And already we are going to go right to our first skip. Because as you know, this guy loves to rehash stuff. But luckily, sometimes at some points they do actually bring in some. They, as in the prosecution, bring in some new arguments and new bits that I would like to point out.
Is he on file right now?
I believe we do.
Yes, no.
But now we're talking about his plea that he says he didn't do.
I've never entered such a plea. My plea is actually Code of Criminal Procedure 2702, subsection 1, an exception to the charging instrument. I raised that issue early on, and I already raised it in the paperwork. I raised the issue that someone fraudulently, vicariously changed my plea to not guilty so that they could go ahead and trigger a trial. But the paperwork hasn't been right since day one. These fellows over here never filed one shred of paperwork, Your Honor. So a case hasn't commenced. I can't go to trial. They've been ignoring discovery. Talk about honoring my rights.
This is definitely a different looking solitude. Whoa.
And there was much rejoicing.
So by you not entering the plea, that is a not guilty plea.
Actually, no. I didn't refuse to enter a plea.
Well, actually, thank you, New York, for the super chat. Artie, Cowboys are trash, and the Giants, they won't win the Super Bowl. Go Giants! Look, I've learned to keep my expectations very, very low. So if you have no expectations, there's no chance of disappointment, right? So that's my motto as a Cowboys fan.
I already entered my plea.
What did you enter?
Code of Criminal Procedure 27.02, subsection 1. 2702 lists out several things, and not guilty is one of them. Guilty, no contest. But the first one on the list is the one that I entered. So I'd ask you to take judicial notice of that subsection 1. There, Code of Criminal Procedure
I don't have it
2702.
in front of me. Can you tell me what it says?
Sure. It says that I make a motion to set aside the charging instrument or an exception to the charging instrument. I actually have both. And it's an exception for cause of form or substance. And my exception is to both of those.
Well, and
It doesn't exist, so it has no form and it has no substance. How can anybody stand and answer for something that hasn't been expressed?
and Judge Holland or myself denied that motion.
You're not sure which motions you denied?
I denied several, and I without going back and looking at them. Yeah.
So she denied a motion to dismiss.
Okay.
A plea can't be denied. That was my plea. And she can't just deny my plea. That's my plea.
Well, the thing is that what they likely did, was they rejected, they rejected what your thing was, which was your contention that the charging instrument was deficient, and then because you refused to enter a plea, they entered the plea for you.
Judge, a motion to dismiss is not a plea. You have three options when you're asked how you plead: guilty, not guilty, or nolo contendere.
Your Honor, I would ask you to take judicial notice
Hold on.
of what I said so you can see his
So what we
life.
won't do is talk over you. He gave you a chance to talk, so let me hear what Mr. Sawyer has to say, okay?
Okay, I don't mind being respectful of everybody here. However, he doesn't belong here. He hasn't shown authority.
He doesn't belong here.
His authority has been challenged here. And he hasn't shown anything. So, yeah, we can let him talk, but just so you know.
When Mr. either fails to or refuses to enter a plea, the court is required, shall enter a plea of not guilty. That's under Article 45.024 of the Texas Code of Criminal Procedure, which states, quote, "The justice or judge shall enter a plea of not guilty if the defendant refuses to plead," end quote.
Yes, Your Honor, notice.
All right. Next up, he continues on with the plea. They go back and forth still, and we're now moving on. So now we're gonna go straight to his. He has 3 pretrial motions we're gonna get through. We're not gonna go through all of it, I promise. But we're gonna go through some of the meatier, some of the whenever there's new stuff to be talked about. 25, 55.
Have you read my motion for due process?
I did.
Okay, so under the heading of no subject matter jurisdiction, there are no primary pleadings, Your Honor. The record of this official court record will show there are no primary pleadings. So if this court tries to operate without lawful authority, that's a crime, Your Honor. It's operating ultra vires, and it's not okay. You can't just proceed without jurisdiction because we're all here. No lawfully authorized individual has come to this court and brought any paperwork to start this.
All right, so we got that one taken care of. That's it. As you know, he continues on with the same crap, different day. But now we're gonna go through. Attorney Thomas brings in a new argument, actually, and we're actually, as a matter of fact, we're gonna bring up the Texas Code, and we're gonna follow along because this is one instance where this guy becomes not just a blathering idiot, but a straight up dishonest liar. So bring up.
Goodness.
The personal jurisdiction argument, we've gone around in circles for hours. We did this for 3 hours on October 6th. You denied his motion. We have personal jurisdiction. We can prove it through our witnesses.
Mr. Thomas?
Judge, if I also may, we haven't argued this section of the Code of Criminal Procedure. I'm hoping that maybe it'll convince Mr. of the authority and the jurisdiction.
It won't.
He's giggling. But let me, with the court's permission, I'll read this section that we haven't argued yet.
Sure.
Code of Criminal Procedure, Article 27.14, subparagraph D as in dog. If written notice of an offense for which maximum possible punishment is by fine only, that's a Class C misdemeanor. That's what we're here for. It's a traffic offense, Class C misdemeanor. Has been prepared, delivered, and filed with the court, an illegible duplicate copy has been given to the defendant. The written notice serves as a complaint to which the defendant may plead guilty, not guilty, or nolo contendere.
Oh.
If the defendant pleads not guilty to the offense or fails to appear based on the written notice, a complaint shall be filed that conforms to the requirements of Chapter 45 of this code, which is the Code of Criminal Procedure. And that complaint serves as an original complaint.
Oh.
I have case law that addresses this. If the court wants, I can read the sections from the case law. But what that is saying is what has already happened here. The trooper filed the citation. Mr. based on his refusal to plead, has actually pled not guilty. A complaint was filed in this at the same time, 2 days after the citation was given, along with another copy of the signed citation. This section of the code has been fulfilled. That serves as the charging instrument. We've been through this with Judge Holland. There's 3 forms, 3 ways to charge a defendant.
Your Honor, he's making stuff up. I object to his testifying.
An indictment,
There's facts not in
an
evidence.
information, and a complaint. Complaints actually have 2 different definitions. One of them, a complaint can be the probable cause to make an arrest, or it can be a charging instrument in a Class C misdemeanor. A complaint has been filed. Mr. has received a copy of that. That's part of the discovery that was given him.
And I would agree with that. I mean, that's the reason why I said when you're saying that nothing has been filed, Mr. That's why my question was, well, did you receive a citation when the trooper stopped you? So,
Okay.
and again,
Let
I
me
agree with
answer
you.
that.
You said we'll get to that, okay? And I agree, we'll get to that. But so, if
Well, let
we
me go
get
ahead and
through-
answer that since that's on your mind right now. And
Sir,
since he's,
well, let me say what I want to say. If we can get through some of this other stuff, we will. We'll get there. But okay, go ahead.
so in my motion here, my motion is talking about that there are no primary pleadings, and so nothing started this case. Well, this sidebar here was about his idea, Mr. Thomas's idea that the complaint is the charging instrument.
Yeah.
And he took us to the Code of Criminal Procedure 27.14, subsection D.
Yeah.
But he didn't read the whole thing.
Now, okay, here's where he decides to be dishonest.
I get it, it's a long piece. But it does describe something in there that didn't happen. This can only happen if the defendant agrees, elects is the word it uses, and signs an agreement with the prosecuting attorney. I didn't agree to that.
Wrong. What he's saying here is wrong.
The reason they carved out this loophole, if you go back and look at the legislative revisions, they carved this loophole out for things like parking or, and it was also back in the day before 1999, before the repeal of 4501, which used to say the complaint is the charging instrument. That's been fixed. Our legislators handled that.
No, so what he's trying to say, here's what he's trying to, well, actually, I think he's going to say it straight up.
It's
I'll
gone.
wait.
That's no longer the case. You can't say the complaint is the charging instrument. He
Yes, you
repeats it
can.
over and over, but there's nothing to back it up except his feelings. And, Your Honor, I can't stand by that. We can't have attorneys saying things and running courts in Texas. This is ruining Texas. We need to have the courts pay attention to what the law says. So if he says, look at 2714D, yes, let's look at 2714D. And let's also notice the part that he left out. The part that says, this kicks in, you can do this complaint only thing, you can have any written.
See how he glosses over that?
Notice it doesn't even have to be a complaint. It can be a citation, it can be
He just glossed over that.
a note scribble on it.
Because what this is saying, what I have in the highlight portion, and what he's talking about, this idea that the defendant may waive, or if a defendant agrees to this, he's trying to make the argument that a complaint can be a charging instrument only if the defendant agrees. That's not what this statute says. It says a defendant may waive the filing of a sworn complaint and elect that the prosecution proceed on the written notice, aka the citation of the charged offense, and the defendant agrees in writing with the prosecution, signs the agreement, and files it with the court. It says nothing about this idea that a sworn complaint can only be a charging instrument with his consent. It only talks about whether or not a sworn complaint is needed to move forward, or that it can proceed simply based on the citation.
A napkin that says, I think you did something wrong. And if the defendant looks at this and goes, yeah, I know, I did it. Yep, I did it, I know. You could skip all the other, you don't have to do all the due process checks and balances. I'm just gonna go ahead and pay. I know it, I did it, yep. I'll take this napkin as, or citation or whatever it is. That's good enough. The defendant can elect to do that and can sign a written agreement. It has to be written in, it has to be signed by the defendant, it has to be signed by the prosecutor, it has to be filed with the court. None of that happened. So I would ask you to take a judicial notice of Code of Criminal Procedure 27.14 subsection D as in Delta, as he has brought up. That didn't happen. Your Honor, we're still stuck with the due process.
Shut up.
They don't have any documents. It has to be something filed by a party, not facts from THP. It has to be filed by a party to the case.
Okay.
Which is also incorrect. I don't know if I'll go to that part of the section, but the requirements of the complaint. No, he's incorrect there. A complaint could be sworn by an officer, a court clerk, or a magistrate, and somebody else.
In regards to the motion for due process, that is denied.
So denied, but he wants to continue on. He says he has more. So we're gonna skip. We're gonna skip to when he is completely denied, at least to this motion, and save you guys about 20 minutes of blather. Right there.
And then proceed, or the court cannot show jurisdiction and has none. It's not something to deny. We don't just say, oh, well, yeah, subject matter jurisdiction, yeah, whatever. It's not something to pass. We don't go, that's a threshold issue. It's called threshold for a reason. So, and I'm saying here in my motion process rights, continue. Yes, okay. And it stands unopposed. Nobody has ever addressed any of the points in there.
Okay. I understand that's your position, okay? The state has, let's just leave it at this. I am gonna deny that motion, okay? So let's move on to the next one. What's your next motion?
Okay.
That you filed? And these were filed.
What's the grounds for that denial of motion for due process?
I'm just gonna deny it, Mr. Okay?
Do you have some grounds for that
I'm not gonna
denial?
give any grounds at this point.
Well, I raise an exception to a denial of due process without any grounds.
Okay, what's your next motion, Mr.?
I have a
Motion 2.
Okay.
This is based on this is all of it.
I know. Just gonna hand them.
Thanks. This motion in limine, Your Honor, is based on the fact that there's been
All right, so
such a strong prejudice against me obtaining exculpatory evidence.
I'm being prejudiced against. So that's his second one. Let's go to the prosecutor, bringing up the arguments again. Most of it is like, I haven't been able to get discovery or subpoena my witnesses, et cetera, et cetera.
Is to say, okay, fine, then we are not going to be able to talk about these things, those particular issues, because they're stopped.
By the way, he did bring his kid here again.
Judge, if I may ask
Sure.
these discovery issues. We went over this for probably about an hour on October 6th. That's all we've been doing all morning is replowing ground we've already gotten through.
Okay.
Mr. doesn't like the answers he's gotten. He didn't like the answers he got from Judge Holland, so he asked her to recuse herself. He doesn't like the answers he's getting from you, so he just keeps regurgitating the same things. But to address the discovery issue, Mr. has had every opportunity between the hours of 8 and 5, Monday through Thursday, and 8 and 4, every Friday, to come up to the Wood County Criminal District Attorney's Office and watch discovery, like other defendants. I myself told him that on October 6th. We provided him with a itemized list of discovery that was available for him to view. He refused to sign it. I provided him my personal email address. I gave him our investigator's personal email address. Neither one of us have got an email asking to set up a time to watch discovery. On November 22nd, I mailed Mr. 2 separate letters, one via regular mail, one via certified mail, to the address he had in his federal lawsuit, reminding him, Mr. You have, if you want to watch discovery, if you don't want to, you don't have to. That's your right. But you have a right to view it if you choose to. Our office address is listed below. These are the hours of operation. You need to come and watch it. Nobody, on behalf of Mr. representing him or Mr. himself, came by the office yesterday to watch any discovery. He's an obstructionist. He's choosing not to take.
Your Honor, I object
An obstructionist.
to all this characterization. He's painting me in a bad light for no reason.
And you haven't been painting these prosecutors in a bad light the entire time? The chutzpah of him to get whiny about being character assassinated in open court. Yeah, this guy.
Well, you've done that to them as well.
He's choosing not to take advantage of the avenues he's been given to address the issues he's raising. It has absolutely no merit whatsoever.
Okay.
And Judge, if I may briefly address this, I know because of time, this is a case, Powell versus Hawker, 516 Southwest 3rd, 488. And it's a Texas Criminal Appellate Court out of, well, it's the Court of Criminal Appeals of Texas, 2017. And I will advise the court, portions of this case have been overturned, but not the discovery dispute that's contained in this case. And if I may briefly read this, it's dealing with section 39.14 of the Code of Criminal Procedure. It says Section A of Article 3914 requires the state, upon the request of the defendant, to produce and permit the inspection and electronic duplication, copying, and photographing by or on behalf of the defendant certain discovery materials, including witness statements. And that's 3914A. Then it goes on to explain. Moreover, the state may provide to the defendant electronic duplicates of any documents or other information described in this article. Despite these statutory allusions to the defendant in quotations, however, when read as a whole, the statute does not literally
Saludos, man.
contemplate
I'm
that
sorry,
the
man.
defendant should be able to personally retain a duplicate or copy
Cheers.
of any of these discovery material other than
remembering.
his own witness statement. Instead, subsection F of 3914 plainly indicates that
Oh, wow,
any
this is
copy
different.
should be turned over to counsel, that the defendant may view them, but the defendant may not obtain copies. It expressly disallows the defendant's attorney from providing to the defendant copies of the information. Even the defendant who opts to represent himself and therefore has no attorney to show him the discovery materials is not entitled to obtain copies, though he must be permitted to inspect and review the discovery materials upon request. The state is not required to allow electronic duplication as described by subsection A to a pro se defendant.
All right. Thank you.
Your Honor,
Yes, sir.
may I speak to that? This case that he's bringing up is not on point, and here's why. It is speaking to a situation, that Powell case is speaking to a situation where the court has ordered for the prosecution to only allow inspection. And that's when these 39.14 limitations kick in. In 39.14, it specifically says, if the court orders inspection only, then all of these things Mr. Thomas said. Then the prosecutor may allow viewing but not duplication. The defendant's counsel may have a copy, but the defendant may not have a copy. Pro se may not have a copy. All of that kicks in if this court orders inspection only. This court has not ordered inspection only. In fact, there's a motion that is still outstanding and live before this court to order the production of that evidence, and it was never ruled on. So,
Did you ever go, so you never did take advantage of their offer to come and?
I don't trust them, Your Honor.
Okay.
To go to their
Don't
city, it's
trust
bad
them?
enough to go to the county. I don't trust them. The federal marshals don't trust them. I mean, I'm not going to go.
Judge, I'm going to object to this. That's completely baloney. Federal marshals don't trust the Wood County District Attorney. There's no evidence at all to that, and I object to his sidebar comments.
Okay, I'll withdraw it. It's true, but I'll withdraw it because I don't care about bringing that evidence up right now.
Okay. Anything else on this motion?
I'm just going to say that. Oh wait, the limiting motion.
Yes, sir.
Let's see here.
All right, so now you heard it. He's whining that he never got a chance to discovery. They're like, we gave him plenty of chances to view discovery. He wouldn't take it. And he admitted that he had the opportunity. What was I going to say? Hold on, I'm skipping through. Oh, that's right. 111.
Okay. Does the state have anything else in regards to this particular motion? No. Okay, thanks. I'm going to deny this motion as well.
Deny my motion in limine?
Yes, sir. I've heard.
On what grounds?
Sir?
On what grounds?
I'm not going to give any grounds at this point, okay? I'm going to deny the motion. Again, I understand your position. I heard everything you said. Let's move on to the next motion that you have filed, and I believe
Denied.
it is judicial notice. Is that correct?
Yeah. Amended.
Yes.
11.
Yeah.
Thank you, counsel.
I'm not counsel.
That's good.
Whatever.
All right. And that's part one, guys. So just like that, we saved ourselves about 40 minutes. We're now going to part two.
So this is the last, yeah, okay, got it. This is the last motion that you filed, correct?
Yes.
Okay. All right, go ahead, Mr.
All right, well, I'm still at arm's length to the court because no jurisdiction has been shown to exist. There are no primary pleadings, so still at arm's length to the court. And I'm bringing this motion, first off, it's judicial notice, and Your Honor, Judge Holland denied judicial notice, and that's something that would be improper. I'll just point out that judicial notice is something that must be taken, shall be taken, when the facts are supplied to the court.
That's assuming that all parties agree on those facts.
So, one thing that can be indisputable fact here is that
All right, so we're gonna he repeats himself again of the whole judicial notice thing. So we're gonna move it on to the 7-minute mark.
that's not what it says. So I would caution this court to pay careful attention to that language.
Judge, with your permission, I have cases here that say the charging instrument is the complaint.
So we're going to hear again about the charging instrument. I know. This is like our 5th or 6th time talking about this. But this part is actually really important because when I was doing some background research into Texas procedure, I stumbled upon a case, albeit unpublished, but a case that is so on point to the situation, it almost hurts. And we're going to take a look at it and look at the pertinent part about this particular situation. Because if you guys have recall, on more than one occasion, the defendant brought up the idea that part of the Texas Code of Criminal Procedure that talks about the complaint serving as a charging instrument in municipal courts has been repealed. He's brought that up several times. He's going to bring it up again, but I'm going to bring up this case that speaks to this argument.
If Mr. wants to argue with that, he needs to go see our legislature. Because this is, they haven't fixed it, Judge.
See, he just said they fixed it, referring to the repeal.
45.018 of the Code of Criminal Procedure defines a complaint. 45.019 of the Code of Criminal Procedure sets out the requirements for the complaint. This complaint that was filed by the state of Texas in the speeding ticket case meets all the requirements for a complaint found in 45.019. This case is Riggin versus the state of Texas. It's a memorandum of opinion, Fourth Court of Appeals out of San Antonio, 2019. And Judge, I can give you all the numbers. It doesn't have a site, but the number.
What is that, Riggin?
It is Riggin, Your Honor. And the first issue is under a charging instrument. Riggin contends his constitutional rights were violated and the municipal and county courts lack jurisdiction based on deficiencies in the charging instruments. Sounds familiar? There are three types of charging instruments: indictments, informations, and complaints. A complaint serves as the sole charging instrument in municipal court. Municipal court...
No, I'm sorry, Your Honor, I have to object.
Let him finish, please.
Municipal court
Just need to
and
object to make the
justice
record.
courts are in the same section, in section 45 of the Code of Criminal Procedure. With regard to charging instruments for offenses punishable only by fine, and it references Article 2714D of the code, provides in pertinent part, and it sets out that code. Thus, for offenses punishable by fine only, an officer's written citation serves as the complaint until a defendant pleads not guilty. A formal complaint in conformity with Chapter 45 is only required to be prepared after a defendant pleads not guilty. In this case, the record reflects Riggin was provided a copy of the citations issued by the police officer who stopped him. The citation stated the offenses with which he was charged. After Riggin appeared in municipal court and pled not guilty, complaints were prepared in conformity with Chapter 45, and a discovery release signed by Riggin shows he received copies of the complaints at least 7 days before trial was held.
All right, thank you. Are you still going?
Judge, if because of time restrictions, I'll stop, but there are more cases that address a complaint is a charging instrument, in spite of what Mr. says it's not. It is.
Okay, thank you.
I think it might be helpful for the court to hear those. I would like to hear them too. I have never found anything.
You want to hear the other cases that he has? I mean,
Yeah. I've never found anything that they're always off point or they've been repealed or overturned. The statute underlying has been repealed or the case has been overturned.
Judge, he references 45.01. That statute has been repealed, but it's been replaced by 45.018.
So that he references that this statute that's been repealed.
45.019.
Okay.
Those address complaints and requirements for the complaint.
Yeah, they do.
okay.
So,
The problem with his logic there is that
I don't really, Mr. Thomas, we don't need to go through the other, I mean, because of the sake of time, we're already over 10 minutes into this motion, and I appreciate you being prepared with those, but Mr. We're not going to go through those right now, okay?
okay.
I would agree that a complaint, that a citation could serve, or that a complaint could serve as a charging instrument, and and I've got a copy of the ticket right here, and I'm certainly not arguing the state's case for them, but I have a copy of the ticket here. It says complaint affidavit right on it, and so I don't see the merit behind your argument that it does not serve as the charging instrument.
Okay, well, let me clarify.
Okay.
The 45018 and 45019 speak to what are the characteristics and sufficiency of a complaint, what does it need to have on there, and that's fine. That doesn't make the complaint become something else.
Okay.
You can't go cook chili off of a recipe based on that document. It is a complaint. It's only a complaint. It is not an indictment. It is not an information. It is a complaint. And even if it does meet all of those characteristics that are required, the lawful prerequisites for it to be a complaint, even if it does, Your Honor, that doesn't make it anything more than a complaint. The purpose of a complaint, if we look at what is the Code of Criminal Procedure 205, it says that they need to draw up an information based on the complaint. Code of Criminal Procedure 21.22 says you file the complaint and the information together. The complaint has never, ever, in any place in our law, it does not say that the complaint vests the court with jurisdiction. The indictment or the information vests the court with jurisdiction.
Don't know why he brings up jurisdiction.
45018 and 19 speak to what makes a good complaint. That doesn't make it something more than a complaint, and that's the clarification I would offer. The case law that he brought up speaks to 27.14D Delta, which we've already gone over. That only kicks in if there is an election from the defendant. The accused says, I agree, I'm going to sign it in writing, I agree.
Again, he lies about this section.
That you don't need to do anything more than a written notice. In that case, sure, a citation can serve as a complaint, but it still doesn't make it. The citation can become an indictment or information.
No one ever said it would.
Even if I had elected and duly signed and filed that in writing with the court. So still, Your Honor, the paperwork doesn't exist to begin anything here.
Okay. All right, I understand your position, Mr.
Okay.
And I've heard everything that you've said.
All right, so we're down to, we finished, I think, page 1 here, and there's 2 pages.
All right, before we continue on with this bullshit or BS, we're gonna look at this case, this part. This case, real quick. Stevens versus Texas. It is Appellate Division, Travis County. And here we go. I'm gonna give you again. I'm not gonna go through the entirety of the case. So at this point, we're not gonna go through the entirety of the case. I'm only gonna go to the pertinent part for you guys. Juan Gall, I'm glad you're here for this one too. A municipal court jury found Stevens guilty of failing to stop at a proper place and failure to display his license. The jury assesses punishments as a fine of $50 for failure to stop and a $200 fine for failure to display his license. County court at law affirmed the judgment. Stevens raises more than 20 issues on appeal in this court. We will affirm the judgment. And I want to get through the background real quick because, again, yeah. Austin police officer Kyle Robertson testified that he observed Stevens' offenses if he issued his citations. He testified that Stevens was traveling northbound in a passenger car on Austin South 1st Street and stopped at a red light. With the car's front wheels in the crosswalk past the designated stopping point. Robertson testified that he stopped Stevens and asked him to display his license, but Stevens declined. Robertson testified that Stevens provided his name and date of birth but refused to show his license on the grounds that he was not operating a motor vehicle for transport. Stevens reiterated at trial his belief that he was not required to display his driver's license. He testified that he was traveling with his wife in their car, but there was no transportation, activity for profit or hire, no passengers or cargo, no passenger manifest or bill of lading. He denied that he was driving the car, but stated on cross-examination that he was at the wheel of the car and that if he put his foot on the brake, the car would stop. He also testified that his car was stopped behind the crosswalk. So where have we heard this before? So again, I'm not going to go through the whole bit, but I want to go through the pertinent part here. Here we go. Stevens contends that this matter is a non-case because the state did not prove notice and subject matter jurisdiction. He relies on the legislature's 1999 repeal of a provision that stated, quote, proceedings in a municipal court shall be commenced by complaint, end quote. See former Texas Criminal Procedure, Article 45-01, the exact same code that this guy cites as saying it was repealed. Stevens argues that since that repeal, proceedings charging misdemeanors must be stated by information signed by a county or district attorney as they are in county courts. Code of Criminal Procedure 205, counties having one or more criminal districts and information must be filed in each misdemeanor case. While the current code does not as plainly state that a complaint alone commences proceedings in a municipal court as it did in the repealed Article 4501, the code still permits that process. We are instructed to interpret statutes so that effect may be given to each and to avoid interpretation that would render any parts of them meaningless. Bloodbook versus State. We must presume that the entire statute is intended to be effective and must consider the object to be attained and the consequences of that particular construction. The Code of Criminal Procedure states that a, quote, complaint or information for any Class C misdemeanor may be presented within 2 years from the date of the commission of offense. 12.02. The offenses for which Stevens were convicted were charged as Class C misdemeanors. The chapter governing justice in municipal courts provides that, quote, for the purposes of this chapter, a complaint is a sworn allegation charging the accused with the commission of offense. 45.018. It also provides that a defendant is entitled to notice of a complaint against the defendant not later than the day before the date of any proceeding in the prosecution of the defendant under the complaint. 45.018. Read together, these statutes require that a defendant is entitled to notice of the complaint charging him with a Class C misdemeanor at least a day before any proceeding in the prosecution under the complaint begins. If we interpreted the repeal of Article 4501 as eliminating the complaint-only commencement of actions in municipal courts, then Articles 45.018 and 45.019 would be meaningless surplusage. We must reject Stevens' interpretation in favor of the reading that gives meaning to the existing Code of Criminal Procedure. We overrule Issue 2 and we deny Stevens' motion to recharacterize these cases as civil cases. And there we go. You'll now learn a lesson in statutory interpretation. And we all know that this guy is full of it. But we're not going to listen to him blather on even more. And we're going to go straight to 1939.
Have anything to add at this point?
Just, Your Honor, that for a court to take judicial notice of any fact, it has to be a fact that's undisputed. These facts that Mr. are citing here before the court are disputed issues that they can argue at trial. They're not facts. They're disputed issues.
I understand your position. Again, Mr. I've heard everything that both sides have said, and again, we are rehashing some of the same things over and over again, and that's fine. But I am going to deny this motion as well, and if this is the last motion that you had filed that needed to be addressed prior to the hearing, we'll go ahead and proceed with the hearing.
Your Honor, on what grounds are you denying judicial notice?
Again, on this, I'm going to deny it, and I'm not going to give the grounds at this point.
No grounds.
Proceed with the hearing, okay?
All right, well, I raise exception to that as well.
Okay.
All three of these, I raise an exception to judicial error in denying things without grounds.
Okay.
These are, okay.
Now we're going to go straight to 31, where now he wants to disqualify the judge. Play.
Before we get started, I'd be interested to see what those other cases.
Reminded me of them, and that we had time to go through all those.
Well, Your Honor, looking at the denial here of a motion for due process, I don't feel confident that I can get a fair and impartial trial from you.
I understand that. I mean, I understand that's your position.
Yeah, and without being allowed to have any exculpatory evidence, I mean, I'm gonna have to ask for your judicial disqualification
Uh-oh.
for cause. I mean, this is bias. I can't have due process. Why are we even here?
Well, I mean, like I said in the beginning, we're gonna proceed with the hearing, okay? That's why we're here. I gave you ample time to argue your motions. We listened.
Thank you, Justin.
The
The 15 months.
We're gonna go ahead and proceed, okay?
Well, you haven't provided any grounds for me to be deprived of due process rights.
Okay.
Oh my God.
I'm gonna have to move for your judicial disqualification. Nothing personal, Your Honor, but I need a fair and impartial trial.
Okay.
Okay.
Does this state have anything?
Yes, you do not have to disqualify yourself. There's absolutely no basis in law or fact for that request. It's meritless. The only way Mr. in his mind is going to get a fair and impartial trial is a judge who agrees with everything he says. That's not how it works.
Okay.
The judgment addressed the exculpatory evidence. The state has a duty to turn over any exculpatory evidence in our possession or that we have access to. The state, the Wood County DA's office, we know of no discovery that would be exculpatory. The only evidence that I have is the citation and complaint. I intend on introducing that through the trooper and the video. Mr. has been given ample opportunities to come view the video. He has a copy of the complaint and the citation. I provided that to him on the October 6th hearing. We literally have no other evidence that I'm aware of. If there is exculpatory evidence, he's never specifically told us what it is. If it's in our possession, we give it to him. We're going to comply with the law.
All right.
So do you have a decision about that, Your Honor? Are you-
We already made a decision.
Step down? Or you-
No, I'm not. I'm gonna deny that motion. Okay?
All right. I take exception to that.
Okay. Since the state has brought the charges, they will always go first. Mr.
And finally, we are at the actual trial. Hooray!
You always have an opportunity to respond, okay? We will begin with opening statements, then the state will have any witnesses testify and provide any physical evidence they are relying on. Mr. You will have a chance to question those witnesses and look at any documents presented. When the state is finished, Mr. You will have a chance to call any witnesses and provide any physical evidence you would like me to consider. The state may choose to put on a rebuttal case. Both sides will then have a chance to make their final arguments. Both sides will have 5 minutes for an opening statement, okay? Mr. Thomas and Mr. Sawyer, you all will go first, so you may go ahead and begin if you're ready.
Thank you, Your Honor.
Thank you.
Judge, I don't know if I'll need 5 minutes or not. This is a speeding ticket case. And I intend, the state intends to call Trooper Nichols to prove our case. That's the only witness that unless there's a rebuttal witness needed at some point, but that's the only case-in-chief witness that we have. As I mentioned, this is a speeding ticket case on August 27, 2022, this year. Approximately at 8:35 in the morning on Highway 80, just west of the city limits of Mineola, Mr. was stopped by Trooper Nichols for speeding.
Objection, Your Honor. He's testifying to facts.
Judge,
It's the opening statement.
this is opening statement. If I can't prove what I'm saying, then he can use that in his case-in-chief.
Yeah, he's given his opening statement, Mr. Okay,
Okay.
all right.
We intend to prove. I'll
There. We intend to prove. That's better.
qualify it. I think I've already said that we intend to prove. I believe the facts will show that Mr. was traveling west on Highway 80 just outside the city limits of Mineola. The posted speed limit in that section of Highway 80 is 50 miles per hour. There are signs to that effect. The trooper stopped Mr. for going 64 miles an hour. Those are the facts that the state intends to prove. Judge, if I may kind of direct your attention The Texas Transportation Code, Section 545-351, maximum speed requirement. And I will advise the court that this is not the whole code for these sections. This is the pertinent parts that fit our case. Section 545-351 says an operator may not drive at a speed greater than is reasonable and prudent under the circumstances then existing. Well, what does reasonable and prudent mean? We'll read next section, 545-352. That's prima facie speed limits. A speed in excess of the limits established by subsection B or other provisions of the code is prima facie evidence that the speed is not reasonable and prudent, and that the speed is unlawful. What that says that any speed over the posted speed is unlawful, and speeding ticket can be given. Judge, I also have Black's Law Dictionary.
Black's Law Dictionary, Pog.
I can find it, but it defines prima facie evidence. It essentially says, Judge, that if the speed is not reasonable and prudent, if it's over the speed limit, that is enough. Prima facie evidence means that's enough to convict the defendant, unless he can rebut this prima facie evidence. Prima facie evidence is enough to convict unless the defendant can rebut it. So that's going to be up to Mr. to see if he can rebut this evidence. So Judge, there's nothing in the statutes that requires the state to prove the exact speed limit. There's nothing in the statutes that require Mr. was driving, and nothing in the statute requires the state to prove the exact time of day or even the exact day. Let me back up. The statutes do say that Mr. is the driver, but we don't have to prove the exact speed limit that he was driving. We don't have to prove, there's nothing in the statute that says we have to prove what transportation means, or it's in the transportation code, or it's...
He's referencing, a lot of the filings this guy does. Again, like I said in part one, at the end of the day, with this guy constantly citing the Texas code, you know what I mean? He's not one of the SovCits who rejects, the statutes and codes don't apply to me. He just thinks that he knows what the code says and tries to twist the meaning of the statutes to his favor. But at the end of the day, he's your standard right to travel, commercial activity only, that type of thing.
Definition. There's nothing that says traveling has to be defined or that it's located in the statutes. And the only reason I mention these words, Your Honor, is because Mr. in some of his discovery has mentioned those words and asking for clarification on that. There's nothing in the statute that even mentions transportation or traveling. So, Judge, I believe that the evidence is going to show that Mr. was speeding on this date that I've mentioned beyond a reasonable doubt. Judge, if the court agrees with the state and finds that Mr. was driving and that he was driving above the posted speed limit and finds him guilty of speeding, the state is asking the court to fine Mr. $99. There are reasons.
All of this for $99.
There are procedural reasons that we're making that request. But we are asking that he be found guilty, be fined $99 plus court costs.
Plus court costs.
Thank you, Your Honor.
Thank you, sir. Mr. You have 5 minutes to make your opening statement, sir.
All right, thank you. Well, I believe that the evidence that we will see today doesn't exist. The only thing that would be admissible evidence is within the 4 corners of a charging instrument. And as they've tried to put this complaint in the place of primary pleadings, the complaint is the only thing that this court can look at to say, what are the facts that evidence can be produced to prove? They can only prove what they've alleged, Your Honor. They're not allowed to prove anything else. So when they want to go and talk about something else over here, this hasn't been alleged. They never alleged anything about driving or operating or speed greater than reasonable and prudent. None of that has been alleged. There are no facts that would allow them to then start attaching evidence and being admissible evidence into this court. So that's why I say I think the evidence is going to not exist. But one thing that I think is very important for this court to understand, I've been in conversation with the DPS director about this, that the whole regulatory scheme, Texas Transportation Code, only applies to transportation, which is, by definition, we can't just go by the common colloquial sense, Your Honor. We need better training for our troopers to attach the regulatory activity has to be happening for the regulatory scheme to apply. And I think we'll see in this case that didn't happen. If I were charged with a violation of some commercial fishing license just because I'm walking in the grocery store near the fish aisle and I've got some tuna in my hand, I'm not in the middle of that regulated activity, so those regulatory scheme terms and conditions don't apply to my activity if I'm in the grocery store. I gotta be out there on my feet doing the actual commercial activity for those restrictions and regulations to kick in. And then the game warden can come and talk to me about that. He wants to see the license, he wants to see the whatever. That's perfectly appropriate in that context. This is another regulatory scheme, Your Honor. This is not applied to soccer mom. This is applied to transportation. And we can't go by what Mr. Thomas would love for us to think that it means, or and not just Mr. Thomas, but really a lot of people in the law enforcement are never trained about this, Your Honor. They don't know what regulatory schemes are, and it's unfortunate. It's kind of messing up Texas.
Jesus. Okay, the arrogance of this guy. Like, these troopers need proper training, and for the record, he actually tried to send his own freaking what do you call it? His own PDF or his own like teacher's manual on educating troopers as part of his filings. I got both copies of them. I'm not even going to bother with it. Suffice to say, it's just another bit of evidence of this guy's arrogance.
Causing a bunch of overcrowding in jails and all kinds of problems. Us versus them, angst. We could eliminate a lot of this if it would be simply illuminated that there is a rights-based usage of the roads and a privilege-based usage of the roads. We the people own the roads, we own our cars and trucks, and if we are soccer mom minding our own business, that's not the regulatory activity that falls under this regulatory scheme that they're trying to roll it into. If we're a business, in the language of this, it says an operator. That's a business term, Your Honor. It's defined in.
No, it's not. Operator is also defined in the transportation code, and it says nothing about commerce or commercial activity.
In the code, you can see that it's only commercial.
No, liar. You're a goddamn liar.
If there is no activity that's being regulated, then it's inappropriate to try to impose the code. You know, if I...
You're driving! That's a regulated activity.
If I would be... let's say... so there's a law on the books under the Texas Code of Agriculture that says that if you are transporting an animal then in your truck, well then you could be fined up to $25 to $200 per animal. Without a permit, you can't transport animals. But if you look at the context, it's a regulatory activity, the commercial activity of agriculture. You have to be taking them to sell somewhere. If I just let a couple of dogs jump in my truck and go with me somewhere, that's not the regulated activity, Your Honor.
The funny thing is that I remember seeing a body cam video. Can't remember, wasn't a SovCit, but I remember distinctly a body cam video of a guy losing his damn mind because the cop was giving him a citation for having his dogs in the back seat of his truck untethered. So you can actually be cited for that in some areas.
And I think they have an impossible hurdle to jump here to prove that I would have been involved in any kind of regulated activity.
Jake, I have about 980 mods.
You know, and as much as I love our troopers, I think they need to get some better training about this key point.
Okay, thank you.
Hmm?
I want to ask you a question. Are you?
Yes.
Go ahead and sit down.
Guys, we're talking about if you're in the bed of a pickup truck. That's what we're talking about. We're not talking about in the cab or inside of the car.
Are you? I want to understand what your argument is. Are you saying that you? Because I'm a little confused, honestly. Are you saying that you weren't operating a motor vehicle that day? Or
Correct.
So you're saying you were not operating that motor vehicle that day?
Correct.
That you were stopped?
Oh yeah.
Trooper Nichols.
Correct.
Okay. And I thought that's what you said, but I didn't think that I was understanding you correctly.
Right. It's because those terms are specifically defined as commercial activity terms.
Oh my God, no, they're not.
And so, in order to be in scope for applying those regulatory scheme and all the terms and conditions that go with some business that wants to operate their business using our roads as a place of business, that's fine, but we the people have, through our legislature, set up restrictions for that. We don't want truckers just running around and, you know, hazardous materials and everything. We've got rules about that.
Okay.
So
All right.
that's where this scheme comes in. Not for Taco.
Scheme.
And not for me. At least not on that day. If I choose to be a Lyft or Uber driver or something, then this would kick in.
Okay.
Commercial activity.
All right. Now we're on part 3. Where is it?
Mr. Thomas and Mr. Sawyer, are you ready to call a witness?
You call Trooper Nichols, John.
Okay. And Trooper Nichols, you've already been sworn in, so you can just come on up.
Now we're doing the trooper testimony.
Trooper Nichols, would you state your name, please?
Nichols,
And how are you employed?
with the Texas Department of Public Safety and the Highway Patrol Division.
And is the term trooper appropriate?
Yes,
So, being with the Texas Department of Public Safety, you're a certified peace officer.
yes.
How long have you been a trooper with the DPS?
Objection. That's irrelevant. How long has he been employed with?
So get ready, guys. I get ready. I would say his experience is relevant. I would say his experience goes to his potential credibility, depending on the circumstances. So I think knowing how long he's been a state trooper can definitely matter in a case like this.
With anything is irrelevant to
It's not.
what they're trying to prove.
It is relevant. He's explaining, you know, what type of experience he has, so.
So would the
Let Mr.
prosecution's
Thomas-
position be
let Mr.
that
Thomas
a
go
new
ahead.
recruit has,
Let Mr. Thomas continue, please.
Over 19 years.
What was your prior experience before becoming a law enforcement, or before becoming a trooper with DPS?
I managed the 1,100 acre cattle ranch directly before this for a couple of years. And before that, I was commercial hay baler. Before that, I did
Commercial hay baler. Oh my God, we really are in the boonies of Texas.
4 years as the Air Force, in the Air Force as a firefighter.
Do you have any other law enforcement experience besides being a DPS trooper?
No, sir.
And you did mention your military experience.
Yes, sir.
object to that as being
What are
irrelevant as
your
well?
duties in your present position?
Previous
as a
jobs.
state trooper?
The general control of traffic, basically, to make sure traffic is safe, obeying the laws of the state.
Hey, Scout.
In order to be a DPS trooper, do you have to have any kind of education, specific education, college degree or anything?
You either have to have a 2-year degree from college or 2 years military.
And you fulfill that through the military?
Yes, sir.
Have you had any special training regarding your duties as a state trooper?
I've had numerous special training for the department. The most relevant in this situation, this case right here, was every 2 years you have to be recertified in the operation of the radar.
And you've been recently certified, is that correct?
Yes, sir.
All right, so he just testified that he was just recently recertified in operating the radar. Relevant information. When he says that you don't need to prove the speed of the car, they're just going by the word of the cop. No. They only need to show that he was driving above the posted speed. They don't need to show that the exact speed he was driving. Just only that it was above the posted speed limit.
On August 27th of 2022, were you certified in the use of the radar?
Yes, I was.
On that particular date, do you remember what your shift was?
6 a.m. to 4 p.m. shift.
So
May I have a copy of these notes that he's using to refresh his memory?
There's probably not a copy available, but I don't see any reason. I mean, he's going over his training.
He's refreshing his memory off of some notes he's got with him there.
I would say if the trooper's refreshing his memory from notes, I'd say it's fair for him, the defendant, to have a copy of that. Yeah.
May I have a copy of them?
Judge, that's a copy of the complaint or the citation.
Oh, it's a copy of, yeah, if it's a copy of the citation, I mean, he should, the defendant, I forgot about that. He's reading off the copy of the citation. If the defendant should have a copy of that of himself. If he doesn't, he's yet another moron.
And I will offer that into evidence in just a moment.
Okay, all right. You have a copy of the ticket, of the original ticket, don't you?
Yes.
Okay. Or
Yeah, never mind.
Citation, all right.
Yeah, actually, I'm going to dispute the authenticity of it because there's no original, but
Okay.
yeah, I've seen a copy.
Okay, go ahead, Mr.
Bingo.
Thomas.
So, Trooper Nichols, on August 27th, 2022, what were your specific duties on that shift?
Just traffic flow, general maintaining.
Do you remember what, or is it multiple regions or areas, or do you remember what area you were specifically in on that morning?
I was working US 80 just west of the Minneola city limit signs.
Were you in uniform that day?
Yes, I was.
Were you in a marked patrol car?
Yes, I was.
What kind of vehicle do you have?
It's a 2020 Chevy Tahoe.
So I know you've got copies of this, but I'm gonna go ahead and hand you, may I approach a witness?
Yes, sir.
I'm gonna hand you what's been marked as States 1 and States 2. Do you recognize those documents?
Yes, I do.
Are those true and correct copies of the documents that you produced on that day?
Yes, they are.
Or as far as the complaint, it was produced 2 days later, is that right? Or both?
This complaint was generated the same time the citation was issued.
Okay. Now, the notary section down there says it was sent or filed August 29th.
That's when she notarized it, yes.
Okay. So it has been notarized.
Yes.
Judge, I will offer in evidence what I marked as States 1 and States 2.
Okay, thank you.
So 1 and 2 is the citation and the complaint.
Trooper Nichols, do you recognize Mr. from having an incident that day involving him?
Yes, I do.
And I know we don't have a record, but normally we ask if you could describe where he's sitting in a piece of clothing so that we can be sure you're talking about Mr.
He's sitting to my left wearing a dark jacket with a blue shirt.
Yeah. This is the man that you stopped about 8:35 that morning.
Yes, it is.
Why did you make that stop?
He was traveling above the posted speed limit of 50 miles an hour.
How do you know he was traveling above 50 miles an hour?
I visually observed his speed, activated the radar. You can audibly hear the higher the pitch of the tone, the faster the vehicle is going. Then I looked at the radar to confirm that his speed was 64 miles an hour.
And before
All right, so he testified that the radar said that he was going 64 miles an hour, and what was it, a 60 zone or a 50 mile an hour zone? I think it was a 50 mile an hour zone.
we get into talking about the actual radar, have you had training? You mentioned you believe him to be going above the speed limit. What kind of training?
Objection, that's not relevant to any fact that's on any of the accusations. It doesn't, you need to lay a foundation.
What?
There's nothing.
Go ahead, Mr. Thomas.
What?
The trooper testified that he believed that he was traveling above the speed limit. What training have you had that would give you the knowledge to know that?
After 19 years of experience, foremost, but like I said, every 2 years we have to be certified, and that's where the sergeant rides with you, and you have to properly get within 5 miles an hour of 20 different vehicles that he documents
And you've had that training.
every 2 years.
So you believe that Mr. was going above the posted speed limit, is that correct?
Yes.
Okay.
Objection, this speed limit that he's talking about is irrelevant.
Okay.
We're here for a speeding ticket. How is the speed limit not?
No, there is a posted speed limit.
Are you testifying, Your Honor?
Oh my God.
Your Honor, I can try to clear that up with the trooper.
Okay, go ahead, Mr. Thomas.
Trooper Nichols, how would you define those signs that have a speed limit on? What should we be calling those?
Speed limit, the maximum speed that's safe for that section of the road.
So would that be under 545.351 maximum speed requirement?
Yes, it will.
Those speed limit signs are the maximum speed requirement.
Yes, they are.
So when you stopped Mr. What type of car was he, or let me ask you this, was he driving the vehicle, the motor vehicle that you stopped?
He was in the driver's seat behind the steering wheel.
Was
Yes.
there any other person in that car?
Yes, I believe his was with him.
Okay.
So it sounds like his kid was in the car too.
This is not old enough to have a driver's license.
No, sir.
And is it your testimony you don't believe he was driving?
No, sir. I do not.
You believe it was Mr. driving?
Yes, sir, I do.
What type of car, vehicle was he driving?
Prius.
The kid's adorable. I just feel bad that he has a dumbass for a father.
Let the
It's a goldish color Toyota Prius.
And is that vehicle a motor vehicle?
Yes, it is.
I object. He's not, the witness is not qualified to identify motor vehicle.
How? He's a Texas State Trooper. Oh my God, he does. So you're saying he doesn't know how to identify a car? I know what he's saying. But he's an idiot.
He is. I'm going to overrule it again, Mr. He is qualified to identify a motor vehicle.
So, Your Honor, you're testifying to his qualifications?
Mr. Thomas, go ahead.
So, Trooper,
Raise an exception to that.
is a traffic stop for a violation of a traffic law considered an arrest?
It's a detainment.
It is a detainment.
So, at this detainment, is if the defendant is given a citation and he signs that citation, you don't normally take him to a magistrate to be arrested?
Do not know.
I will say the fact that the attorney Thomas, he's been asking a lot of leading questions up to this point. Most of them aren't that big of a deal, but I'm actually shocked that this guy hasn't been objecting to the forms of questions. Maybe I'm just used to freaking Daryl Brooks.
Did this traffic violation occur in your plain view?
Yes, it did.
I object to his term traffic. That's
Oh my
a
God.
commercial term that
Shut
hasn't been
up.
established here. It assumes facts, not in evidence.
Overruled.
Grounds?
Any grounds for that?
No.
No.
Trooper Nichols,
Freaking Giga Chad. No.
did you have probable cause to make this stop of Mr. vehicle?
Yes, I did.
And you already testified that in your belief he was traveling above the posted speed. Is that accurate?
Yes, that's true.
Your Honor, I have to object to this as well. The leading question that's being offered here is even inappropriate because it's not the officer who makes the determination of probable cause.
I will say I actually agree with this objection. The way that Thomas asked the question. No, hold on. Let me go do that. I hate to say it. I actually do, but I agree with this objection. There we go.
Object to this as well. Any grounds for that?
No.
Trooper Nichols, did you have probable cause to make this stop?
See, the way he asked that, Trooper, did you have probable cause to make this stop? He can't answer that question. That's asking the trooper to make a legal conclusion. That is the object of the judge or the jury or the judge or the jury the judge as a trier of law to make that conclusion that he had probable cause. So the way he asked that question, I agree, is inappropriate.
Mr. vehicle.
Yes, I did.
And you already testified that in your belief he was traveling above the posted speed. Is that accurate?
Yes, that's true.
Your Honor, I have to object to this as well. The leading question that's being offered here is even inappropriate because it's not the officer who makes the determination of probable cause. It's the magistrate after the officer gets the person before the magistrate. Yes, he has to have probable cause or it was a bad stop, but he's not the one that gets to decide and tell everybody for the court yes or no whether he had it.
Judge,
That's the magistrate's
I'll
job.
rephrase the question. Trooper Nichols, as a peace officer, did you believe you had probable cause to
That's the better question.
make this stop?
As a peace officer, do you believe that you had probable cause to make the stop? That is the more appropriate question to ask.
There you go.
Yes, I do.
What direction was the defendant's car going at the time of the traffic stop?
West.
So he was leaving Mineola?
Yes.
Is Highway 80 a public road?
Yes, it is.
Is that located in Wood County, Texas, at least the section where this stop occurred?
Yes, it is.
What was the weather conditions on that day? Was there anything dangerous or rain or anything like that?
No, sir. It's just a light cloudy day.
So were you stopped on the side of the road checking traffic as it passed you or coming toward you?
Both.
Trooper Nichols, are you familiar, on the complaint, you specifically give the specific citation for the transportation code that was violated? Section 545.351 and section 545.352. Why did you put those sections of the transportation code down on this complaint?
Those are automatically filled when you click on the violation portion of the ticket. It just automatically pre-fills them all there.
Is it also, it says 10% or more above posted speed. What is the reason that's on there, if you know?
I don't know.
Is that automatically on there?
Yes, sir. That's just
Was the speed that he was traveling 10% or more above the posted speed?
above 10%, yes, sir.
So would this give him an indication of what he's receiving this citation for?
Yes, it should.
Objection. That's not within his, he's not qualified to answer that question.
I don't know. I would say he would be. I would expect that a trooper with proper training would know what the code that's imprinted on a citation is supposed to mean.
Whether or not I would have adequate notice of something or understand something based on his opinion.
I'll rephrase the question, Your Honor. Should a reasonable person understand that temper?
See, I don't like that question either because that calls for speculation. But I'm trying to figure out how the best way of being able to ask this question. But I think that's more a question that would be left up to the jury. I think what he should ask the trooper is that, or he already asked the trooper, I think, the most of what he can ask, and that whether or not that information that's on the citation is sufficient for a reasonable person to know what they've been cited for would be a question left for the jury.
Percent above the posted speed.
Objection. He's asking for speculation about what should happen.
You want to rephrase the question again, Mr. Thomas?
Judge, I can.
Okay.
Then move on.
Trooper Nichols, when it says 10% or more above posted speed, and if the posted speed is 50 miles an hour, then that would tell you, and should tell Mr. that he's going more than 5 miles an hour. That's 10% of 50 over the posted speed.
Rambling
Is that
leading
right?
question.
Is that correct?
Yes.
He's leading the witness on direct.
He was rephrasing the question like I asked him to do. So.
Yeah, he's a paragraph's worth. He needs to ask a question, not a paragraph. He's testifying. And he's effectively using the witness to say yes while he testifies. It's called leading on direct. It's not allowed, Your Honor. It's not admissible.
I understand, but it's overruled. He did rephrase the question, and the trooper answered it.
So, Trooper, again, how did you determine that Mr. was speeding?
Visually, audibly, and through the radar itself.
Was Mr. speed constant?
At 64, yes, until he slowed down when I made the traffic stop.
So he didn't just passing the vehicle or some other reason speed up to 64 and
No.
back off?
No, sir.
It was constant.
Yes, sir, it's a constant 64 miles an hour.
Was there other traffic present?
Yes, but it was very light traffic.
I think you heard, you've been in the courtroom, Mr. was referring to privilege to travel on the roads and right to travel on the roads.
Objection.
I don't agree with him, Thomas, bringing this up because we're not there yet. And what I mean by that is that Thomas is bringing up what the trooper overheard him say outside of the stop itself about SovCit's right to travel and stuff. We're not there. We're not there yet. He's jumping the gun and talking about that. And so I'd actually agree with the objection here.
That never came up. I never mentioned anything about these items he's describing.
Okay. If he mentioned that, do you have any idea what that would mean? Right to travel or drive on the roads or privilege to drive on the roads?
Your Honor, this is a crazy leading question that has no foundation. He's going way off in the weeds and leading the witness, and it's irrelevant. This doesn't go to anything that's on any charging instrument.
He's questioning the witness.
I would agree. At this point, it's not relevant. At this point.
Right, but he's leading and he's going to things that are irrelevant. Irrelevant,
I agree it's in the weeds,
immaterial.
Judge, but I remember the opening statement, we were in the weeds for a long time, Mr. So, just trying to figure out.
Go ahead, Mr. Thomas.
So, Trooper, if those words were used about the right to travel on the road or use the roads or privilege, do you know what he would be referring to?
There's a group that DPS has encountered that considers themselves sovereign citizens
Still funny though.
that don't believe that the laws that are passed by the legislatures apply to them. So that's what I thought.
Would you consider the right to use the roads privileged?
I would object to relevance. The trooper's opinion on whether or not the right to use the roads is a privilege or not, it's not really relevant. His opinion on that. Anyway.
Yes, it is a privilege to drive on the roadways.
Because you have to have certain
Your Honor, it's
requirements.
immaterial whether he has an opinion about sovereign citizens or whether he has an opinion about
Well, he testified to
rights.
He believes that it is a privilege to drive.
It's immaterial.
So, okay, overruled.
So when you turned on, did you turn on your emergency lights or activate them to stop Mr.?
Yes, I did.
When that happened, what did Mr. do?
Mr. pulled over to the right side of the roadway, which would be the north side of US 80, and came to a stop.
So after he pulled over, did you activate your body camera and the dash camera?
Yes, I did.
Have you reviewed those videos?
Yes, I have.
Do you have a copy of that video with you today?
Yes, I did. And I've already provided it to the court.
Has that video been edited or altered in any way?
No, sir, it has not.
It's a true and accurate depiction of the stop as it occurred that day?
Yes, it is.
Judge, I would ask that, I would offer that video into evidence before we publish it, but I'll go ahead and offer that video into evidence based on Mr.
I would object to it being offered into evidence. I would be surprised. I haven't had an opportunity to see it yet.
Okay, so now we're going to listen to the body camera footage of the stop itself. He's complaining that he didn't get a chance to watch it. We already established that he had plenty of chances to watch it beforehand. And also he's going to argue that it's also irrelevant. No, I would say the body cam footage of the stop itself is very relevant to this case.
Okay. I'm going to overrule the objection. It is being accepted into evidence. Are you wanting to go ahead and...
I would ask if we could play that video
Okay.
on the body cam portion, Your Honor.
I believe we've got it all set up.
Judge, I will go ahead and inform the court. I don't think it's very long. It's either 7 or 9 minutes.
Okay.
Your Honor, I have another objection about this, is that it's not relevant to anything that's been alleged.
Okay.
Okay.
Overruled.
Overruled.
Can everybody see the video okay?
Yep.
Lights?
I see it.
Okay.
I know, guys, I know. You have no idea how effing annoying it got listening to this video over and over again. I can't help with the snorting. I'm sorry. I'm so sorry. Ah! While we're in the lull, I'm gonna get. I think there's only one other like light.
Trooper, is this where the radar showed he was speeding?
Yes.
Morning, sir. How patrol?
Good, Marty.
Not to be driving fast.
I don't know. I think it's just a safe thing to do.
To speed?
Well, no, sir. Driving at safe speed.
When you have to go at or below the speed limit. Huh? You not agree with that?
No, I'm fine with that.
Well, you was doing 64 back there. Speed limit's 50.
All right.
You got your driver's license?
I'm sorry.
You have your driver's license?
Get ready. I'm glad I refilled my drink too, but get ready.
Is anything I'm about to give you here you're asking for? Is that going to be?
No driver's license. You just need your driver's license. It's only need that phone number.
Is that going to be something that you can use against me in court?
Well, by law.
You hear that sigh? Is that something that could be used against me in court?
You're required to hand me a driver's license when I pull you over for a traffic violation. So do you have a driver's license?
I do. I wasn't using it right now.
Well, I need to see it.
If I give that to you, is that going to be evidence that you're going to try to use against me in some kind of...
Well, I've got to identify you. Do you understand that?
Yes, sir.
I can't just write John Smith on a citation. It has to be your name.
All right.
And your identification.
All right. I'll do it to you.
I feel like the trooper's accent is even heavier at the traffic stop than he is in court.
There it is.
Thank you. You still live in Michigan?
Yes, sir.
You just down here visiting? Do what? Well, Rick, give me a daytime phone number. And this is just in case you forget to call the judge, they give you a courtesy call to remind you so I
won't forget.
Okay.
I won't forget it all.
Give me a phone number.
Well, I'd rather not.
Oh, that's fine. That's fine. Hang on. I'll get you out of here. Lord have mercy.
Lord have mercy.
Trooper Nichols, what are you doing right here at this point in the video?
Entering his driver's license information into the computer, mobile CAD, and issuing the speeding citation.
Is that someone else in the vehicle? That
That's
voice?
a radio talk show.
citation comes out of the computer, what else is gonna come out with it?
The complaint affidavit attached to it, and the violator's copy that we get to deal with the court information on it.
And on that notice, there is a date for him to appear for court, or before, on or before that date.
Yes, sir, just call only.
So the trooper at this point, it was a little hard to hear because of traffic noise. Did he ever deny to you that he was traveling 64 miles an hour?
No, sir.
Your answer, no?
Dude, does this cop have a freaking bubble jet printer in his freaking car? What the hell?
I got a printer in there.
Now, this right here is the judge's information.
Not Matrix, that's right.
Call him by the 30th of next month, okay?
Oh, I guarantee you, I'll be on that. Thank you. And if I don't sign it,
It doesn't matter.
could you get us in front of a magistrate on your FaceTime right now?
That signing is not a plea of guilty, just promising to contact the judge.
But if I wanted to see a magistrate right now,
Not on Saturday, they're not open.
that's true. Can I have a copy of that?
Yes, sir.
Okay. Thank you.
Y'all be careful now, okay?
I appreciate it.
Yes, sir.
Trooper Nichols, is it your testimony you gave him a copy of this citation?
Yes, it
What about the complaint? You give him a copy of the complaint also?
is. No, sir, not a copy of the complaint.
So did he answer, when you asked him, or you told him he was going 64 miles an hour, and he answered you were driving safely, what did you take that to mean?
That he knew he was traveling above the speed limit, but didn't want to admit to exactly how fast he was going.
And again, let me kind of go through the radar to wrap this up. A radar device was used to determine exactly how fast he was driving.
Yes, it was.
And you've already testified, I believe, you had training and instruction in operating that radar, is that correct?
That's correct, yes.
And that training and instruction has to be recertified every 2 years?
Yes, sir.
And do you operate a radar on a regular basis in your official duties with DPS?
Yes, I do.
How often have you been, or how long have you been operating this particular radar unit?
Your Honor, I object to relevance.
Judge, I need to show that he's experienced on
Yeah, I would say that's very relevant. His experience with the radar gun is extremely relevant, you dumbass.
operating this.
So we don't need to know how many fingerprints has the radar on it. This is irrelevant. It doesn't go to anything that's on
Troopers
the...
testifying to how much experience he has operating a radar. I think it's relevant. It's overruled.
This particular unit, I believe I've had it for about 7 years now.
And I don't need an exact amount. How many times have you operated this radar unit and stopped somebody using it?
It had well over 1,000.
How do you know if the radar unit is operating properly?
Before and after each shift, we do an external calibration, and after each citation, we do an internal calibration. If at any time either one of those don't come out correct, the citation is voided.
So if you believe that there's something wrong with that radar unit, you automatically just void that person's ticket?
Yes.
And you didn't void Mr. Fountain's ticket this day?
No, sir, I didn't.
Does that mean that you believe that radar unit was working properly?
Yes, it does.
Had you used that radar before stopping Mr. on that day?
Yes, I have.
And was it working properly then?
Yes, it was.
Did you use that radar unit after stopping Mr. that day?
Yes, I did.
Was it working properly then?
Yes, it was.
Where the hell did he go?
Trooper, based on your experience, training with this radar unit, do you have any doubt that Mr. was speeding that day?
None whatsoever.
And you're familiar with these statutes in the transportation code, is that right?
Yes.
If you were to read these out loud, do you believe Mr. violated these statutes on that day?
I object to the relevance of these facts this is depending on him having some facts that are not in evidence.
No. Him asking, do you believe, which is an appropriate question, the appropriate form of question, do you believe that he violated the speeding laws?
Judge, I'm not sure what that means, but facts not in evidence. But
There would have to be some facts that show a foundation for his belief to be somehow important.
He was there at the stop. He testified that he stopped you. He testified that he saw on the radar that you were driving over the speed limit. What?
He keeps talking about trying to figure out, like, how much does this guy believe whatever he's
Well, I think his
testified to.
experience,
The level of his
training and
belief
experience.
hasn't had any foundation. There's no facts.
Thank you, RA, for the $99.99 super chat. Retainer payment to hire you to sue this naughty SovCit for my emotional damage. JK, and you couldn't tell. Thank you, RA.
To show.
Yes, that I do believe so, yes.
he violated this statute on that day.
Yes, he did.
Is this statute, in your opinion, does it mean that any speed over that posted speed limit is speeding?
Yes, it does.
And again, Mr. in your opinion, based on your training on the radar, he was traveling 64 miles an hour.
Yes.
Pass the witness, Your Honor.
All right, thank you. Mr. Do you have questions for Trooper Nichols?
I do.
Okay, go
Okay.
ahead.
Thanks for being a trooper for 19 years.
Here we go.
Yes, sir.
Where were you? Why were you in that place at that time?
Just working traffic control in that area.
On somebody's orders? Or you just
No,
go
sir,
around?
I'm free to work anywhere that I want to.
All right. So, enforcing traffic. Have you been, what body of law were you enforcing? When you say enforcing traffic, what body of law is that?
You refer to the transportation code.
Texas Transportation Code?
Yes.
Would that be the body of law that contains the accusation that you made on the complaint?
Yes.
Yes.
On average, about how many Texas Transportation Code violations do you issue?
In a
Per
day.
week, per year, whatever, per month? Just give some idea of what that looks like, the volume of it.
Of average of how many traffic contacts I made or citations I issued?
Citations that are based on Texas Transportation Code.
Per week, I would say it averages maybe 5 or 7 a week. maybe.
What word would you use to describe the activity that is regulated by that Texas Transportation Code?
All right, guys, get ready.
What word would I don't understand the question.
How would you describe that activity? The activity that Transportation Code, you're enforcing this Texas Transportation Code. What word would you use to describe the activity that gets regulated by that Transportation Code?
Judge, I'm going to object just on the basis of vagueness right now because I don't understand his question. So I don't know what word he's seeking, but the legal objection would be it's a vague question.
Can you rephrase the question, maybe clarify it a little bit more? Because I'm confused on the question.
Okay. Well, that's important. The Texas Transportation Code has one activity that it regulates. Can you specify that word, that activity?
Judge, I'm going to...
Oh my God, he wants the trooper to say commercial, and the trooper's not going to say commercial because that's not how this operates.
Object as to his testifying that the Transportation Code has one word that it regulates.
That's my way of rephrasing the question because you couldn't understand.
Well, the Transportation Code regulates all traffic and many regulations. So
you don't get to testify.
Okay, all right. Mr. Could you rephrase the question so that it's easier for everybody?
Okay, so
I don't know that he's going to be able to pick out one word that you're looking for. So could you generalize your question a little?
have you been trained to recognize that the activity that's regulated by Transportation Code is transportation? That transportation is what is being regulated by the Transportation Code. Has that been your training?
Are you trying to refer to commercial vehicle training or commercial traffic or civilian traffic? You trying to differentiate
And so the trooper finally gets what he's trying to say here.
those two? Because the Transportation Code...
There is a
applies to both.
differentiation of those, but I'm not talking about that. I just mean the whole Texas Transportation Code. Is it your understanding from your training of 19 years that that activity is that the regulatory scheme is regulating transportation?
Yes.
Kind of think I see where you're going as far as transportation, but I'd have to ask you, are you referring to floor power, that only people that are getting paid to operate on the roadways? That's what the transportation...
Well, yeah, I was going to ask you about that too. What's your understanding of the definition of transportation?
Transportation code, there's multiple laws in it referring to, just specifically in this case, speed on the roadways. That all TxDOT, they do different surveys for each section of the roads to find the maximum safe speed that's allowable, and that's what. Me as a Texas Highway Patrol, I enforce the speed law specifically because speed is a factor in every crash. And after you work your first fatality, you don't like writing speeding tickets because you see what speed does. So I hope that answers your question.
Yeah, back to the regulatory part. Yeah, I get why. But as far as the regulatory scheme, is it your understanding that that is not relating to fishing, it's not relating to building code, it's not relating to copyright infringement, it's relating only to transportation?
Now, see, I don't believe it should be classified as a scheme. It's a set of rules to keep the public safe on the roadways.
I was gonna say too that I noticed it too, and the trooper also noticed it too, that his usage of the term scheme implies something nefarious or negative. Scheme has a very negative connotation associated with it.
Okay, that's fair. But is it your understanding that that scope of that set of rules is transportation and nothing outside of transportation? Is that your understanding?
No, sir. It has to do with the operation of vehicles on the roadway.
Right.
All vehicles.
Okay, let's go to definitions of motor vehicle, definitions of
Okay, now this is where I would start objecting.
Driver.
But
Actually, let's start with transportation.
oh my god.
What's the definition of transportation?
Dictionary definition of transportation?
Judge, I'm gonna
No,
object.
you're enforcing it, so you
Judge,
need to
I'm
know
gonna
it.
object. That calls for a legal conclusion, and the trooper is not a lawyer. So, he's not qualified to answer that question. Calls for a legal
Your Honor.
conclusion.
If the prosecutor's going to say that his sole witness over here is unqualified to know what that means, then all of his testimony is inadmissible as unqualified evidence.
No, it wouldn't be inadmissible. The best you could say would be that it's not credible. It wouldn't be inadmissible. You dumb. Oh my god, I want to say so many curse words, but I have to control myself. But no, the best you can argue is the credibility of the trooper, not that it's actually inadmissible.
Because he has to be qualified to enforce what he's saying he's enforcing. He has to know what it means.
And in addition to my first objection, this isn't relevant. This section of the Transportation Code has nothing in it about transportation, so any definition of transportation is irrelevant.
Your Honor, he can't say that top center word right there, transportation. He even wrote it down and maybe forgot, but it applies
I don't have a
to a
problem.
certain scheme.
I don't have a problem with the trooper answering the question about what he believes the definition of transportation is as it regards to the transportation code. However, I don't necessarily see the relevance of that.
I think you will.
If that's, I don't have a problem with him answering that question if he wants to, you know.
As far as transportation, people, individuals moving along the highway, either carrying themselves or carrying additional passengers.
So when you say carrying, are you talking about somebody that brings their son along, or are you talking about somebody that has been paid to be behind the wheel?
No, sir, anybody behind the wheel, whether they're paid or not paid.
And he just owned himself.
That's your understanding. So which law defines that? When you go to step out there and enforce these 5 per week, which law are you relying on to give you that scope, to give you that guideline to say, here's what I'm enforcing?
The transportation code.
That's the law that they violate, and if they're sitting behind the steering wheel and operating that motor vehicle in my presence, then they're either...
I understand. I'm saying, what law would you rely on?
Objection, he's not allowing the witness to answer his question.
For you to have an idea that you're seeing what you think you see.
This law...
You think you see somebody operating a motor vehicle, you think you see a driver, and you think you see transportation happening, but is there a law that you can reference that you can say, yeah, I remember this from training, or I looked at the Constitution, or I looked at
The transportation code.
something, and here's my basis for believing that I'm seeing operating a motor vehicle, all of that.
All that.
The first part of your question where you said, I think I see,
Mm-hmm.
I'm the only person I had to rely on what I actually observed.
Right.
Ha!
But you're using legal terms that have legal definitions that have to be used. And if you don't know the definitions of those terms, then your perception has no basis.
He is also, I would have objected, Jassa, he's using compound questions too.
So that's why I'm asking you for the law.
Judge, I'm also going to object, he's assuming facts not into evidence, saying that these have legal definitions that he's not aware of. Those haven't been produced into evidence.
Your Honor, his objection has been stopped by his own admission that these terms have been admitted into evidence, and these terms have been in my discovery for admissions. These terms are out there, and he admitted to them already.
Okay.
So you can't say they're not in evidence. They are in evidence, and they don't even need a court order for it. The rules are very clear that it's considered admitted without the necessity of a court order.
Okay, go ahead and ask your questions.
I'm just looking for the laws that he believes that he's enforcing. Where is he getting these definitions? Because he's saying, yeah, I think I see somebody operating a motor vehicle. I think I see somebody speeding. He's basing this on training, but I'm asking him to base it on the law.
The law specifically that we're referring to that's on the postal board.
Right, but it has some legal terms there. Transportation, operator, driver, motor vehicle, these terms, where are you getting your understanding of these terms?
I'm going to agree with Mr. Thomas on this. It's not his job to interpret. I mean, he's not an attorney, and, you know, so I think you're kind of going down a rabbit hole that and I don't even really see the relevance of it. So.
Okay, well, I can describe the relevance to you, I guess, in closing statement, but the point.
Is somebody like sanding wood in the background? What is that noise? I'm only just now listening to that.
Is I'm asking him to give a law as the basis for his interpretation of these terms that he enforces every day.
He's not an attorney, okay?
Mr. Thomas is saying he's not qualified to do that.
Daddy just said, is he sharpening a knife? Like, she said sharpening a knife. I'm like, I'm thinking in my head, somebody's like sanding wood or something like that.
Because he's not an attorney. But I'm saying if he's unqualified to define these terms, then he doesn't recognize.
Oh, darn it. Hey, Juan Galt, spoilers. Yo, Juan, spoilers. You just let it out that I was going to highlight that exact case, Perkins versus State.
As the behavior when he sees it. He doesn't know what a motor vehicle is if he operates only on his training or his understanding, his assumptions, presumptions. None of that is admissible. And so I'm asking for a law to back it up.
The law we're referring to right now is the ones that are on these boards.
Okay, but that doesn't have any definitions of the terms. It's just using the terms. All right.
That's exactly why those terms aren't relevant, Judge, to today's proceeding regarding a speeding ticket.
Do you know, Trooper Nichols, do you know if those definitions are state or federal definitions?
Oh my God.
The state of Texas uses them.
Yeah, uses them, but how about defines transportation or
Kraken, we got thank you for the $10 snacks for Monday Night Football. Good luck. Thank you, Kraken. We're gonna need it, but thank you very much, man.
In order to look for a definition, do you know whether we're going to look in the state or the Fed?
Oh my God.
I look in the state jurisdiction. I don't enforce federal jurisdiction.
Right. But for the definition.
Judge, again, I'm going to object to relevance. It's just not relevant to this proceeding today.
Okay, I'm going to sustain that objection. I don't see the relevance. And again, you're going down a rabbit hole that I don't think is
That's really important, Your Honor.
pertains to what we're
It's
doing here in regards to
extremely relevant. And
this hearing. Okay, go ahead and proceed.
have you taken the DPS training that's necessary to determine and recognize what is or is not the regulated activity?
Referring to all of the laws of the state?
No, the regulated activity being transportation under the Texas Transportation Code. I'm not talking about all the laws of the state, Texas Water Code and copyright infringement. I'm talking about just Texas Transportation Code.
Have I been taught the Texas Transportation Code? Yes, sir.
No, have you been taught to distinguish, recognize what is and what is not regulated activity? Or, in the alternative, have you just been trained that if you think you see somebody in a car, well then that's fair game, go get them?
No, sir. The
You know what I mean?
operator of a vehicle has to commit a violation before I will interact
Sure.
with them.
A violation of the Texas Transportation Code, which you recognize.
What you're doing right now is you're trying to manipulate the questioning. Okay? And you need to ask questions that are clear, that are understandable by everybody.
Okay.
And I understand what you're doing is you're using words and you're trying to twist your questioning around, and what you're doing, you're being manipulative by doing it.
Ooh, manipulative.
I think probably most people in this room recognize that. So what I would ask is that you ask questions of Trooper Nichols that he can answer in one or just a couple of words,
Okay.
and that are easily understandable for people that are not so gray that you don't even really understand what you're asking. Okay.
Okay.
Is that fair?
Yeah, I'm gonna ask you a yes or no question.
Okay.
Have you been trained by the DPS? Have you taken some DPS training that helps you distinguish between this is transportation, this is the regulated activity, here's what it looks like, versus this is something that looks similar but it's out of scope? Have you?
Oh my God. Again, he's trying his best to ask the trooper whether or not he can tell the difference between commercial and non-commercial. Again, it's, yeah.
Had any training like that?
My answer is they're both connected, whether it's what you said, regulated versus unregulated. If you're transportation, if you're traveling on the roadway, the transportation code applies.
I don't understand his question. I mean, his answer.
Well, of course you don't understand his answer because you're an idiot and you want him to answer in a way that suits you, and you know, and yeah, he knows he got screwed right there. The trooper just shut him down immediately. He said, if you're on the roadways, the transportation code applies. And he doesn't like that answer.
I was looking for a yes or no.
Well, I'm not sure he understood your question.
I'm asking yes or no. Has he had some training? The training that he may or may not have had is training that will teach him to distinguish between what the regulated activity looks like.
I would object, assumes facts, not an evidence. He's assuming that there is a distinction between commercial and non-commercial activity when it comes to traffic laws. Again, we have to elaborate here because there are, separate statutory provisions and regulations that are distinguished between commercial and non-commercial. But when it comes to things like speeding, stopping at a red light, stopping at a stop sign, reckless driving, DUI, etc., 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 it applies to everybody.
Back to my example about the commercial fisherman in the grocery store. What does the regulated activity look like? Can the fish and game warden go and get somebody who has a couple of tuna steaks?
Shut up! This is a stupid ass analogy.
I'm asking him a yes or no question that says, has he had this certain kind of training to say, I see this marker, I see this happening, I see this, therefore I believe this is transportation, and therefore I would find a violation of the transportation code because he's doing transportation.
He's already answered that.
No, I'm asking about the training to distinguish the two.
He has answered that.
Was there a yes or no there?
That was my objection, Your Honor. It's been asked and answered.
What was the answer?
Yes.
Yes, he has had training to distinguish?
He covered his training at the very beginning of his testimony.
That was irrelevant.
Okay. I'm not going to go ahead and keep asking your questions.
Have you had that training to distinguish between what is and what isn't?
What is and what isn't?
It's a loaded question. I wish either the judge or a freaking prosecutor would say it's a loaded question. It's assuming facts, not evidence.
Yes.
Okay. So please describe for this court how you distinguish the two.
Judge, I'm going to object again as vague. If he's asking a specific question about a specific regulated activity, he needs to name that activity so this trooper can answer it truthfully.
I agree. It's sustained. You're asking him to define the difference between two items that you have, two terms that you're bringing up that aren't even really relevant to what we're talking about.
It's highly relevant. It's the only thing relevant here.
Oh.
So Trooper Nichols has just testified that he has had training to distinguish between the two. And I'm asking him to describe that. How do you distinguish it? When you see it, how do you know? Describe for the court.
Hi.
Describe for what specific answer are you
Judge,
looking?
that's my objection again. This is vague. He's trying to trap the trooper into testifying to something, but he's not, he's being too vague to be
And that's
specific.
exactly what I said a few minutes ago. These questions are very gray. It's like they're not real definitive, and I believe that you're doing that in an effort to manipulate the questioning okay? And I've asked you to stop doing that once, and now I'm asking you a second time.
Well, what do you have in mind when you talk about manipulating?
Exactly what I said, okay?
You
You're
said
not
something
gonna-
about
you don't get to
twisting terms.
question- so here's what you don't get to do. You don't get to question me, okay?
I would like to understand.
All right. Finally, the judge is starting to like. I'm getting tired of your BS.
Like I said, you don't get to question me, okay? So what I'm telling you is, I want you to stop manipulating the questioning, and I want you to ask him definitive answers that he can answer in one word or just a few words. Not define two terms that you've come up with that nobody in this room probably has ever even knows what you're talking about, okay? So I'm gonna be real nice until it's time to not be nice, okay? So keep asking the questions, but I am gonna run this hearing. You're not, okay? I'm the judge here. You're not, okay? You're gonna stop talking over people. You're gonna stop manipulating what we're doing here. Right now. You hear me? Thank you.
So, Your Honor, I don't understand what you exactly want here. You're accusing me of manipulating, and you're accusing me of twisting terms. However, these terms they're core to any kind of an accusation that somebody's trying to make here is the applicability of the code that he's intending to enforce.
Statutes and codes don't apply to me. Drink.
I'm not questioning that he's authorized to enforce it. I'm specifically asking questions that go to whether he's recognizing the behavior that he's been trained to recognize. I don't understand how to not manipulate if that's
The trooper has
manipulation.
testified to his training. The trooper has testified to his experience.
Yes. Number of years, yes.
And you've asked him how many tickets does he write in a week? That's experience.
Yes.
You've asked him how many, Mr. Thomas asked him how often he uses his radar,
Right.
which you objected to, but it was relevant. I mean, he has testified to his experience. He's testified to his training. But you're continuing to ask the same questions. I mean, you're beating a dead horse, okay? And then you want to question.
And the reason why he keeps on asking the questions is because he's not getting the answer that he wants. And at this point, everybody's lost their patience.
Me on what I'm trying to lay out to you. And so you can ask the trooper questions. That's absolutely your right. But you've got to ask him questions that he can answer.
All right, so was that question you couldn't understand that question?
Ask me a question.
To just say, I was saying, please describe for the court how you distinguish between those two. You said you've had the training to distinguish between the two. And
I
those
need you to
two.
repeat which two you're referring to.
Right, okay. So that was the activity that is regulated and activity that is not regulated. How do you distinguish between those two since you've been trained?
I guess common sense. Something that's regulated versus something that's not regulated.
Common sense?
Okay. What's your scope and your mission for what kind of traffic you, DPS, are tasked with regulating?
That refers more or less to our motto, courtesy, service, protection. We do our jobs to try to save lives and keep the safe traffic flow on the highways of Texas.
Appreciate that. Do you know that the scope and mission is specifically commercial for hire traffic?
And there it is. There it is.
Judge, I'm going to object. That's assuming facts in the evidence, and those facts have not been admitted into evidence.
Actually, those facts have been introduced into evidence, and judicial notice is mandatory for Texas Administrative
Shut up.
Code.
Judge, those facts have not been admitted into evidence. You did not take judicial knowledge of anything, and that is a disputed fact.
He is correct. They haven't been. And so if you want to rephrase the question or ask the question a different way, you can try.
It's just a yes/no question. I mean, is he aware that that's the case.
Again, it's assuming facts, not evidence. Are you aware that you beat your wife? What?
And if he's not, then he could just say no.
I'm going to sustain the objection.
So that question's out.
Right.
Okay. Do you know, yes or no, do you know where we can read the plain language that what your authorized scope is? Do you know where we can
Relevance.
read that?
That's yes, I do know where we can read it.
Could you tell us?
It's the criminal law book. I think it's the 19 to 21 issue version. I don't remember the name of the top, but it consists of all of the laws of the state of Texas that I'm authorized to enforce.
Okay. Do you believe that there is such an offense as speeding?
Yes, I do.
Yes.
Yeah, I kind of gathered that.
Objection. We don't need his added commentary in his questioning.
What are the elements of this 545.351 and 352? Can you tell us the elements?
Elements.
Mhm.
That would be an individual operating a motor vehicle or some type of mobile device that's traveling above what is posted for that section of the roadway. Now, if they're the one actually operating that implement, traveling above whatever the posted speed limit sign is, that's a violation of the transportation code.
Are you aware of the other elements related to collisions and on down through there? It lists other elements. Are you aware of those?
The gentleman object to relevance. This isn't a hearing.
I would object to the relevance because we're not talking about an issue involving a collision. The attorney already established that it's a prima facie case for violation of the speeding statute occurs if it's been shown that you were driving above the posted speed or the listed speeds as listed in the statute.
About any collisions, this is about speeding laws.
Your Honor, I think it's relevant, and here's why. If an offense has a certain number of elements that have to be met in order for that offense to have occurred, then I consider it highly relevant that someone who's going to accuse another of that crime needs to know what all of the elements are so that he can say, yes, I saw all of these things happening. That's why I think it's relevant.
Okay, go ahead and ask the question again.
Are you aware of the other elements in there about collisions?
There's different laws relating to collisions, if that's what you're asking.
No, I was asking if you're aware of the elements of this one that weren't written up here about collision.
Collision is a little different.
Just
As
yes
far
or
as
no?
speed, you have to have speed to have a collision.
Just
Correct?
yes or no?
I would say yes.
Yes, you are aware of the collision elements?
Then I don't understand exactly what you're getting at.
Okay. I'll just run with that. Did you witness any collisions?
No.
Relating to this aspect?
Right, yes.
No.
No.
And did you witness any hazards related to this?
Yes.
You did? Could you
Yeah.
describe those hazards?
14 miles above the posted speed limit.
Not the answer that he wanted.
Or something that's defined in here. They're not something that's...
Inadvertently, speed in itself of itself, the faster you go, the less time you have to react to something
Sure.
pulls out in front of you, so that's why I issue speed violations.
So, did you
Yeah. So if you're driving 14 over, he's going to argue that's a that's a hazard. You're driving too fast.
witness any other hazards or anything that you consider a hazard besides pure speed?
Not with you on that day, no.
Okay, that's what I was getting at. What are speed signs for?
Oh no.
Common sense, people should look at them and observe them, different speeds for different sections of the highway. Yeah.
It's for the drivers to be aware of what is the maximum posted speed limit so that they know how fast to drive in that particular area.
Higher speeds in rural areas, you have lower speeds in metropolitan areas. It's just to regulate the safe flow of traffic in that area.
All right. What does the law say that the speed signs are for?
Don't go above it. That is the speed that TxDOT has come up with for that section of the roadway to be safely operated in. So whatever it's posted at, that or below it, is the safe operating speed of a vehicle.
Are you aware or not aware of, so I'm trying to make this into a yes/no. Are you aware of the targeted audience, I guess you could say, for these speed signs? Who are they for?
Well, all right. I know where he's getting at, and I got something for this too. Because again, another example of this SOB being a dishonest. Okay, I'm doing my best. I'm doing my best to not curse. But another example of him being dishonest.
That's your understanding?
Yes.
Okay. Can you estimate how many hours in the past year you have spent reading our constitutions?
Oh my God.
Relevance.
And I'm going to say it's relevant because he has other duties besides traffic.
Well, I agree, it's sustained. It's not, how many times he's read the Constitution in the past year, I don't see any relevance to this hearing.
Okay. Have you sworn an oath to uphold the Constitution?
Yes.
Yes.
Thank you. Appreciate that. Really do. Do you spend much time reading it?
Not much.
No, just name, objection, relevance.
Okay.
Dude, are you serious? Really? How often do you spend reading your oath? Oh my God. Or how often do you spend reading the really, dude?
Mr.
Yeah, Scott's got the right idea. Do you know what the Third Amendment is?
We have to limit you. I'll give you about 10 more minutes to ask questions, okay? And then we'll be at noon, and then we'll have to keep moving, okay?
All right. What is the name of your instructor and the rank of your instructor?
What?
For which course?
For Texas Transportation Code.
I don't remember the name.
Okay. Has it always been one person, or do you?
No, it's
you
more.
get different people? You go in every couple of years and you get somebody else?
No, you get, I don't know how many hours during the training academy that you have a couple instructors come in, and then every 2 years or so we go back to in-service down in Austin, and they'll touch on different new topics.
Okay, but that's not. I'm aiming to understand here. If your training is something that you, on a regular basis, you have somebody who's feeding you this information, this training, and helping you on, or is it just kind of hit and miss? You show up every once in a while because it's time to get your hours in. Is that kind of more the style?
Yes, we have multiple different instructors.
All right, so that helps me understand about the training. What articulable facts did you see on that day, the day in question here? What articulable facts did you see that would lead you to reasonably believe that regulated activity was happening?
Oh, God.
Judge, I'm going to object again as being vague. If he has a regulated activity he wants the trooper to answer, he needs to tell him what regulated activity he's talking about.
Can you be more specific, Mr. Fowler?
Sure.
In your question.
Sure. Texas Transportation Code. The transportation activity. Or even, let's put it this way. What articulable fact did you see that led you to believe that some kind of commercial for hire activity was
There it is.
happening?
I thought that's what you was getting.
See, at the very least, at least the cop knows what's up. The cop is already well aware of what he's dealing with. So I at least appreciate that. The trooper knows exactly what he's getting at.
Judge, that's what I'm going to object. He won't use the word speeding, and that's what we're here for. He wants to manipulate an answer based on his question, and he just needs to ask questions that aren't vague and that are relevant to our trial.
I agree, and the objection is sustained, and I've addressed it multiple times with your questioning, Mr. And so, and you're going to act like you don't know what I'm talking about, and I realize that, but you do know what I'm talking about, and so I want you to change the way that you're manipulating the questioning.
So it sounds like at this point, everybody, not just the trooper, but I feel like the prosecutor still doesn't understand what he's getting at. I feel like I honestly feel like the attorney Thomas still doesn't understand what's going on. This might actually be his first encounter with a SovCit, but it sounds like finally the judge, the trooper, and the district attorney knows what's going on.
So that you can ask direct questions and get direct answers. Okay.
Your Honor, I'm happy to ask questions in a more and more specific way because attorneys don't necessarily understand the question, or they want to figure out something they can object to.
Oh, the attorneys just don't understand. Oh, that's it. Gotcha.
Well, the problem is the questions are so vague that it's not. They're just vague. I mean, they're.
Are you saying that I'm asking for a vague answer, or I'm asking it in a way that is hard to understand?
I believe that you're asking questions in a vague manner that don't necessarily elicit a direct answer.
Okay. Let me think how I can rephrase this. When I'm asking about articulable facts, I'm looking for something that you would respond in a way like, oh, I saw some hazardous materials placards that were on the back of your vehicle, or I'm looking for you to say something like, oh, I saw you were hauling logs. That looks to me like a commercial activity. It probably is.
The troopers already testified to what he saw. He said he saw a gold in color Toyota Prius.
So he would have to see
westbound on Highway 80.
Right.
And you pulled over to the north side of the road. So I think if he saw placards or you hauling logs or a commercial type vehicle, I think he would have already answered that question.
Yeah, he probably would have, but I'm asking him, what are those articulable facts? For example, in a little Prius, the question that might be answered by, oh, I saw you had a pink lift light that was all lit up. So I figured you were in service. That would be my reasonable articulable fact. I'm asking him to articulate what he saw that makes him, did he see anything that makes him think there was commercial activity going on?
So just ask him that.
Didn't. Okay. Okay, did you see anything that you could describe and articulate that made you think there was commercial activity going on? Okay, thank you.
That wasn't that hard.
Jeez.
I thought that's what I said before, but I guess maybe I said it differently. Okay, cool, thank you. I think that's, I don't have anything else to ask you.
Okay. Mr. Thomas, Mr. Slaughter, you got follow up?
No, no.
Okay, thank you. Yes, can the witness be excused?
I have no objection to him being excused, Your Honor.
Okay, thank you. Trooper Nichols, thank you very much.
Thank you.
Thank you.
Do you have any other witnesses?
No other witnesses. We rest other than possibility of rebuttal witnesses if needed.
Okay.
We rest our case in chief.
Okay, thank you. Mr., do you have any witnesses to call?
I wish.
Okay.
You've disallowed everyone.
So you don't have any witnesses here today to call to testify?
Nope.
Ha! Well, that sounds like a personal problem. All right. We're almost there. Guys, we're almost at the finish line.
Do
Last
you want
one.
to testify?
Yes, I would.
You would like to testify, okay.
Yes.
You've been sworn in. If you want to, well, I'm okay if you stay right there, actually. Or you can come up here. So if you testify, then they'll be able to ask you questions.
Judge, I would just ask that if Mr. wants to testify, that's obviously fine. However, I would ask the court to admonish him again, just to remind him that we cannot compel him to testify. We
Right.
cannot compel him to give any evidence against himself.
Right.
So if he wants to waive that right, he certainly can do so,
Sure.
but he's not required to by any means.
And I covered that at the very beginning of this. Do you remember that?
Yes.
So you do not have to testify. You don't have to say anything.
Right.
And you're asking to waive that right because you do want to testify. Is that correct?
Well, I have zero confidence in due process because it's been denied at every turn.
Okay.
That also, I should have, since there's been nothing of admissible evidence presented, they haven't even met the bar of scintilla. They certainly haven't met beyond a reasonable doubt. So I should be able to rely on my presumption of innocence and just go with, they got nothing. They came with a nothing burger. But I also understand that the deck is stacked here. So I'm willing to testify for that reason.
So you do want to testify
Yes,
and waive your right to not testify, correct?
right to not testify.
Your right to not speak. Mr.
Yes.
Thomas,
I think
Mr.
I
Sawyer, okay, you're ready to call it, right? Then do you want to come up here or do you want to stay there at the table?
Here's good, because then I've got my notes here.
Okay.
Thanks. These speed signs, we can see in Texas Transportation Code 201.904 that the purpose of the
Texas Transportation Code 201.904. Let's follow along. Oop. Nope, wrong one. Where was it? You're right. They did try their best to get him to not testify, but he's a moron. Ay, Dios mío. Nope, wrong one. Here we go. 201.904. Speed signs. So he's gonna go. Oh, I'm not even showing you guys. 1 second. There we go. All right, speed signs. This is what he's gonna. This is what he's citing to right now.
speed signs is for those commercial.
Let me stop you, and I'm sorry.
So what he was going to say before he was stop is that it says the department shall erect and maintain on the highways and roads of the state appropriate signs that show the maximum lawful speed for commercial motor vehicles, truck tractors, truck trailers, semi-trailers, and motor vehicles engaged in the business of transporting passengers for the compensation for or hire, aka buses. So he has this here, and this is this guy's smoking gun. This is his smoking gun, saying that these speed signs, these speed limits are only for commercial vehicles, and he has it right here. This is his trump card.
Since you are testifying, the state actually will question you first, and then you can testify after the state questions you. But they get to go first since they're the ones that bring the charges.
That's weird.
Judge, he can testify in the narrative. He can't argue the law. He can testify in the narrative as to the facts.
Okay.
But once he does that, when he's done, then we'll cross our.
Okay. All right. That'll be fine. Go ahead.
Okay. Let me testify to the fact that on that day, 8/27, I was aware of the purpose of those speed signs.
Okay.
having read the Texas Transportation Code and having seen that speed signs, the purpose of speed signs, it says that they are for the commercial activity. That's 201.904. On that morning, 8:35 in the morning, when I encountered Trooper Nichols there, I had a knowledge in me that the purpose of the speed signs is very well defined. It's clear. The speed signs are not for non-commercial activity. It's straight up clear. It says why speed signs are there. Oh.
Well, he says it's true. That's it. That's it. Open and shut case, right? Let's go back to 545.352. What he was cited for, the prima facie speed limits. And let's go to section C. What does section C say? The speed limits for a bus or other vehicle engaged in the business of transporting passengers for compensation or hire, for a commercial vehicle used as a highway post office vehicle, for highway post office service in the transportation of United States mail, for a light truck, and for school activity bus are the same as required for a passenger car at the same time and location. I rest my case. Thank you and good night.
I'll read it to you in a moment, but the
So I want to make sure I understand what you're saying, Mr. Are you saying that the speed limit signs are only applicable to commercial vehicles, but they're not applicable to
none of that.
commercial vehicles?
It specifically says, the department shall erect and maintain on the highways and roads of this state appropriate signs that show the maximum lawful speed for commercial motor vehicles, truck tractors, truck trailers, truck semi-trailers, and motor vehicles engaged in the business of transporting passengers for compensation or hire, buses. Well, on that morning, when I was just hanging out with my, there was none of these description of any of these activities, so I was not the intended audience of those speed signs. The speed signs, I didn't make this up, Your Honor. When I went there that morning, out there on Highway 80, as Nichols testified, I had in myself an understanding of what the speed signs are for. They're not for me. I wasn't any of these. I wasn't the truck tractor, the truck trailer, semi-trailer. I wasn't engaged in any of these commercial activities that are described. And it specifically says commercial compensation for hire. That's not me, and I knew that. So I was minding my business, being safe. There was wide open road ahead of me, extremely light traffic, like probably
3 cars a minute.
Probably one vehicle in sight and not near. So there were no potential hazards. This 545-352 speaks to hazards and circumstances, and the circumstances were ideal. Now, I was borrowing my wife's vehicle, and it's better at miles per gallon than it is at miles per hour. But if I had been on some Ducati motorcycle and I could go 200 miles an hour, that's the perfect morning for it.
Did you just hear what he just said? He basically said, well, I mean, if I was in my Ducati motorcycle and there's nobody around, I can go 200 miles an hour. Sure. You know, why not? Right?
And you don't think you would have been violating any laws by doing so?
I would have been pretty unsafe.
Well, no, that wasn't what I asked you, but you'd have been violating any laws, though, if you were driving 200 miles an hour on a motorcycle on Highway 80.
Well, that's a subjective
That's a good question.
question that probably could go to reckless endangerment, and I think I could have been violating that one over in the penal code. But
And that's his freaking weasel out of there. Well, it could be in reckless endangerment, but he still would say that he's not subject to the speeding. Not subject to speeding.
as far as Texas Transportation Code, these would not have been violated unless I had a collision with a pedestrian or
There
a
it is.
motor vehicle that was properly entering the roadway ahead of me, and the collision's cause was my excessive speed, which I failed to control the vehicle because of excessive speed, that's when those would kick in. If I didn't have a collision, these can't happen. There is no crime, there is no offense of maximum speed requirement or prima facie speed limits. Those don't exist unless there's a collision, and it specifically says, oh, you made that really small. It specifically says that the collision shall control the speed as necessary to avoid colliding with another person or vehicle that is on or entering the highway in compliance with the law. So they have to be entering properly. It can't even just be a random person walking across the street, and I can't even have a collision with a tree or a fence post and call that speeding. It would be...
It's all I almost said it, but I stopped. His whole argument is that the only way he can be charged with speeding is if he actually hits somebody else or hits another car. He's saying that even if he crashes his vehicle going 200 miles an hour and hits a tree and somehow survives, he still can't be cited. He still can't be cited for it.
Something else that I did wrong, but not this. And they're not accusing me of reckless endangerment. They're not accusing me of other laws, which I probably could have been breaking and going 200 miles an hour. Yes, to your point, I agree. But I'm saying that morning, I had an understanding of what the speed signs are for. I'm not making it up. I already read it. I knew it. I don't think Officer Nichols knew it. When I was asking him about that, and I think maybe you thought that was vague or irrelevant, but in my carrying on my own affairs peacefully and safely that morning, it was clear to me that I was fine. I was not in any kind of offense territory. I'm not doing any commercial activity, so I can't be put in the category of these people who are, truckers and carrying these things around and have to or even transporting passengers, like you have to 15 or more or 8 or more. There's these different things that it says here, buses. I wasn't even doing any of that. So the commercial for hire activity is straight up clear, and I knew that. So I had no problem, no compunction with just being safe. Just keep safe. It was a nice sunny morning, and we're just being safe. We're not doing anything that's unusual or strange. There were excellent weather conditions for if somebody wanted to go faster than that. We weren't really going all that fast. We were just being safe. And there were no railroads. About these hazards, it says something about hazards, and Officer Nichols testified to his belief, which I don't think is relevant, but the hazards that it speaks of here are railroad crossing, intersection, going around a curve, approaching a hill crest, traveling on a narrow or winding roadway.
Oh.
These are all hazards that someone should pay attention to with common sense, like you said, and make adjustments accordingly. So you might have a posted speed sign says, which is again for the commercial drivers, and we that are not in commerce can look at that and say, oh, well, speed limit just went down, and maybe there's some hazard here. Oh, look, there was a driveway going across. Good, I'm glad I slowed down, or something like that. In this case, there was none of that. There were no hazards. So it didn't apply to me, my activity that I was doing. Speed signs are straight up, word for word. It doesn't apply to me. And so I have no problem with being out there and just being safe at the speed that happens to be safe. Not going back to the 200 mile an hour speculation thing, but just, you know what I'm saying?
That'd probably be a little unsafe, wouldn't it?
I agree.
An idiot, but he still said it wouldn't fall under the definition of speeding. He still wouldn't.
So I was not in a motor vehicle.
There it is.
I was not operating or driving a motor vehicle, and no evidence has been produced that shows that I was. So,
Well, hang on just a second. Say that again.
I was not in a motor vehicle. I was not.
Yeah, the judge needs to hear this stupidity once more for impact. That he just admit that he no evidence was ever there that he was driving a motor vehicle, even though they admitted that he was driving a Prius.
Operating or driving a motor vehicle, like these terms up here are, we have to use their legal definition. And, you know, I could use colloquially, I could say, oh yeah, I drove down to the grocery store. But in the legal sense, here we are in a courtroom, legal definition is what matters. So you have to look at what is the legal definition of these things. And I happen to have looked them up before. So on that morning, in myself, I knew that I was okay to be doing what I was doing. It wasn't a crime. It wasn't any kind of regulated activity. It wasn't any offense of any kind known to the state of Texas, because I've read the definitions. And I've seen that the speed signs apply to commercial activity. And I've seen numerous court cases that have...
Oh yeah. The standard court cases, what? Chicago Motor Coach, Shapiro versus Thompson, Thompson versus Smith.
Distinguished and shown that there's a privilege-based use. Everybody talks about, driving, operating a motor vehicle, that's a privilege. And it's true, it is. That commercial activity that businesses want to use our roads, it absolutely is a privilege. And we have to have a license for that. Anybody that wants to do that has to have a license to go get involved in that regulated activity, that commercial activity. And I realize that it seems a little difficult, and you were referencing about manipulating, and I don't mean to harp on terms more than we need to, other than that those terms have legal definitions. And I get that you know, Mr. Nichols over here was uncertain about these terms, and it seemed vague to him because as he testified, he's coming from a perspective of everything applies. Soccer mom, everybody.
Yeah.
And that perspective is pervasive, but it's not upheld in court. The high courts...
It is upheld in court all the time.
...have said we have a right to use the roadways, and there's a privilege to use the roadways for business.
I notice how I think he's actually more self-aware. Notice how he will not say right to travel, because I think he knows that right to travel has the same connotation as sovereign citizen. So I feel like he's intentionally avoiding using that phrase.
These commercial, all this, they both exist. And so I, having read these cases and having spent some time to understand that, and having seen things like 201.904 in the Texas Transportation Code tells what the speed signs are for. And when we know the truth, it sets us free, right? We look at that and we say, oh, okay, now I know what that's about. I know what that's for.
Oh my God, the arrogance of this guy. Once I educate, you know, the troopers and the masses, you know, we'll all be free. We'll all be free.
There's no confusion. Now, somebody who hasn't had the training might be confused about that, and somebody who has maybe spent a lot of time looking at non-law, like Cliff Notes sort of derived from the law. They've had some training, TMCEC or whatever. They've looked at things and they said, well, this is how we're supposed to do it. And the assumption is that all activity is regulated. But that assumption has not been shown here. It's not before this court. And if somebody wants to try to say that all activity falls into the category of Texas Transportation Code, I'm going to need them to establish that. So that morning, I was out there just being safe and knowing what I know, realizing that these speed signs don't apply to me. It was just being safe. That's all there was to it. It wasn't any kind of, we weren't doing drag racing with anybody or things like that. Nothing that could go to a penal code offense and say, this peace officer has reasonable probable cause or reasonable articulable suspicion to consider this to be a criminal activity. So there wasn't any criminal activity and there wasn't any regulated activity, either one. And so that's what I'm saying. When I was not in a motor vehicle, I didn't operate a motor vehicle, I didn't drive one, I didn't engage in any kind of harmful activity, and I didn't engage in any activity that was, inherently unsafe. So, yeah.
So yeah, that's it. This guy.
I believe that I was being reasonable and prudent. They speak about reasonable and prudent over here. They've highlighted that for us. They didn't write the whole thing. I hope you understand that. They said something about they cut pieces out. Yeah. So, but they've got up here about reasonable and prudent, and I believe I was being reasonable and prudent. Okay. Maybe there was a time, 20-something years ago when I might have had a different category for what I thought, because I thought I was invincible. But, I'm very mindful.
Thank you, Original Vintage, for the $5 Australian. This strategy has been lost by SovCit 2,000 times in a row. How many more losses do they need before they realize the strategy doesn't work? The problem is, Original Vintage, is that this guy in particular, he's a true believer. No amount of losses will change his mind. And for many of these guys, the losses will only embolden them. To them, it's mere proof of the corruption. So it won't change their mind. You might change a couple of minds. People who just thought that they could get get out of jail free card, not true believers. But for this guy in particular, no amount of losses will change his mind.
It's just gotten to the point where I'm okay having in the front seat. And I'm extremely mindful about safety and about what's reasonable and prudent. That's top of mind for me. I'm not in a hurry to get somewhere. I care about safety a lot. So what's reasonable and prudent under the circumstances then existing, I was well within that. No question in my mind. And there has been no evidence to the contrary other than a pure number that was his opinion, Officer Nichols' opinion, Trooper Nichols. So let's see here. Just for clarity, transportation is a term that is defined. It's defined by, it's something that was adopted from the Fed to the state. All these different states adopted the federal, and
no, they didn't.
It's super clearly defined. It doesn't involve me. Nothing I was doing falls into this category. And they're trying to avoid, Your Honor, they're trying to avoid going there because they can't prove that it did. They would need to be able to prove that as the very first primary essential element is, I was involved in the activity that this is regulating. Then they can start to apply these other things about, well, was he really being reasonable and prudent, or does the speed sign apply to him? First element that they are not going to, and they don't want to talk about it because they don't have any evidence to support it, that I was doing some transportation activity that puts me into that regulatory scheme, or like he said, set of rules. If there's anything else I think I need to bring up.
We're a little over 15 minutes since you started in this.
You want to take a break?
Are you getting close to wrapping up, or are you finished now, or do you have more to add?
Yeah, I need to think about it and consider what else needs to be raised.
Well, you'll still have a chance for a closing statement.
Would you like to take a break and
Well, the state
continue.
gets an opportunity to ask you questions.
All right, I'm not sure if I'm finished with my testimony.
Okay, do y'all, let me ask this. Do y'all want to take a break for lunch and come back, or do you want to just keep plowing through and and get this finished and then go to lunch. It's entirely up to whatever y'all decide.
Why just them?
Judge, I'm in favor of just going through.
Okay, all right. Are you okay with that, Mr.?
I'm okay.
All right,
with
we're
it.
still
I have
going.
no preference one way or the other.
Okay.
I mean, I'm hungry, but I'd like to see this get over with too.
Well, it just puts us out another hour, then we take an hour for lunch, we're back here at 1:15 or 1:30, and then, we have to get started back, or we can just keep going and maybe take a 5-minute bathroom break if y'all want to, and then we can hopefully wrap it up within the hour.
We've got some gallery here too. Does their opinion matter?
Sure, yeah. What do y'all want to do? Y'all want to take a 5-minute break? Okay, let's take a 5-minute, ma'am?
5-minute break.
Okay, let's take a 5-minute break, and we'll come back, and then when we come back, the state will ask you questions, okay?
Nice.
Can I get you anything, Judge? You can go through that door.
Yeah, I'll do that.
And then, because there's yours. Logan.
All right. Yeah, take my shoes off.
All right.
Thank you. I'll put it away.
Figured you might be long in the better boss.
He's an amazing man.
Mr. Sawyer,
Clubs doing the same thing.
it's nothing personal. It's just if you.
Oh, here we go. Hey, listen to this. Listen to this, and listen to this guy's obliviousness. Again, this classic narcissist arrogance. But listen to this.
Might want to sit back here. Just wanted to ask if that was okay. If you wanted to.
Mm-hmm. We can sit with you.
Yeah, we just want to sit by Jared, I think.
Okay.
So.
Figured you might be long in the better boss.
He's an amazing man.
Mr. Sawyer, would you be up for telling me these cases? He brought a bunch of cases, but he doesn't really feel comfortable to talk to me.
I don't either.
If you can't hear that, he says something about Attorney Thomas saying he didn't want to talk to him about the cases that Thomas wanted to bring up.
Really? I don't quite understand why.
Well,
And he just said, I don't understand why Attorney Thomas doesn't want to talk to me.
you filed a federal lawsuit on him, my boss. You filed bar grievances on him. I'm sure you
And
filed one on me. I just haven't gotten it yet. The fan club's doing the same thing.
There was much
So-
rejoicing.
if you didn't hear that, he said, well, the other district attorney said, well, you filed a federal lawsuit against him, which he did, and you also filed bar grievances against him. So
That's not what I meant. I mean, it's nothing personal. It's just if you.
nothing personal. How the hell is the attorney not supposed to take it personally if you file a bar grievance against him as well as a federal freaking lawsuit? I take it personally too.
He's a whole person, dude. Oh, God.
Oh. All right.
Again, all for a freaking speeding ticket.
curious about those cases because it seems like they're really hard to come by.
Words and the law.
No, this
Question, Mr.
Should I come sit up there?
It doesn't matter, you can stay there.
We have no questions, Your Honor.
No questions, okay.
No questions.
They have no questions. All right.
That was quick.
No. Oh, by the way, guys, thank you for the $5 super chat. Is what your character on the game is wearing your go-to court outfit? No, I do not wear light and heavy armor when I'm going to court. No.
Yeah, I'm just sure. Okay, and Mr. You have no more witnesses, correct?
No witnesses. We've been over that.
Okay.
I have a lot of witnesses and they weren't allowed to be here.
That are here. Okay, at this time, both sides will have a chance to make a closing argument. Each side will have 10 minutes if you need that long. You don't have to use the 10 minutes. You can reserve up to 2 minutes of the 10 for a potential rebuttal.
Reserve?
Yeah, I also want to clarify, I don't even go to court these days. I haven't been to court in like probably over a decade. Yeah.
Two.
Sir?
Say it again?
The state, they'll go first. Okay, so they can reserve 2 of their 10 minutes
Thank you, Robbie. Thank you for the 5 gifted memberships.
for rebuttal after you go with your closing argument.
Okay.
Does that make sense?
And then when am I going to be speaking?
They'll go first with their closing argument. They have 10 minutes. Then after they're finished with their closing argument, you'll get to make a closing argument. After you're finished with your closing argument, they will have an opportunity to make a rebuttal if they so choose.
Gotcha.
And then we're finished.
Okay, I think I follow you.
Does that make sense?
Yes.
Okay. All right. Mr. Thomas, Mr. Sawyer, it's all yours.
Judge Elton, I'll be brief.
Okay.
I would like to reserve the 2 minutes
Okay.
rebuttal at the end of Mr. closing argument.
Yes, sir.
Judge, this is a speeding ticket case. The citation and the complaint are clear. The citation says violating 10% or more above posted speed. And also in that same document, it says alleged speed was 64 miles an hour. That's never been rebutted. There is no rebuttal about why he was traveling that fast. Therefore, section 545, 352 kicks in. That's prima facie evidence that he was exceeding the speed limits. The defendant was traveling at a speed greater than the posted speed. That's not reasonable and prudent.
I object.
And
He's
that speed is
testifying.
unlawful.
He's making his
Closing arguments.
closing argument right now.
But that hasn't been established with any evidence.
Officer testimony.
Is he allowed to testify?
Shut up.
Go ahead and proceed, Mr. Thomas.
Judge, the complaint is totally within the requirements of section 45.019 of the Code of Criminal Procedure. Starts in the name and by the authority of the state of Texas, ends against the peace and dignity of the state of Texas. In between, it lays out every single requirement that's in that section. The complaint is valid. The citation is valid. And I guess the most important thing, Judge, is just to note when Trooper Nichols stopped Mr. He never denied speed. In his direct exam, he's never denied that he was traveling over 50 miles an hour. His whole exam was about it doesn't apply to me. Judge, can you imagine what our country, what our state, what our county, what Rains County would be like if speed limits were just suggestions? I'm constantly kidding the people I'm with when we get passed by cars and I say, well, those speed limits are just suggestions. I guess there are people that believe that, Judge, but that's not the law. Our country, our state would be in total chaos if that was the case. Those are the maximum speed requirements. posted speed signs. Mr. was exceeding that speed, and it's unlawful. He was speeding. This is a speeding case. Judge, I'm asking the court to find him guilty of speeding pursuant to this transportation code section. I'm asking the court to fine him $99 and court cost. And again, there is no evidence of why I'm requesting the $99. I can't go into that. There's procedural issues that the state of Texas, the Wood County District Attorney's Office is asking you to fine him $99.
All right, thank you, Mr. Thomas. Mr. You'll have 10 minutes to make the closing argument.
Okay. Would you like me to stand up, or?
You can, however you want. You can stand if you want, you can sit if you want. I have no preference.
All right. Well, Your Honor, the state has failed to make their case. They had a document which they're trying to pretend like is primary pleadings, and procedurally it's messed up. They can't start with that, but they're trying to use that, and on that document there are 0 facts. So Mr. Thomas here continues to talk about this is a speeding ticket, to sort of kind of connect with you about this is a little nothing, this is, we all know what this is, and sort of bypass the due process that is needed here. And I would point out that the Texas Code of Criminal Procedure 38.03 speaks to presumption of innocence, and it says all persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. Here we have no elements. They keep pointing at this poster board, but they haven't even included all the elements on the poster board, and they haven't introduced any facts that go to those, some admissible evidence that we could say, oh, yeah, it looks like all of the elements were met. So it says here, nobody can be convicted of offense unless each element of the offense is proved beyond a reasonable doubt. It goes on to say, the fact that he has been arrested, confined, or indicted for, or otherwise charged with, they're trying to pretend like I've been charged with, but it says the fact that he's been arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. So the charging instrument, if this can be called a charging instrument, does not give rise to inference of any guilt. The fact that it exists, that somebody wrote up something that says they think I was doing whatever they think I was doing, that does not give rise to inference of guilt at his trial. So I would point out that there's not been, the state has failed to make their case. Now, I don't have to prove my innocence. I have a presumption of innocence. We should start with the presumption of innocence. And I realize they want $99, but that's not the point here. The point is they failed to make their case. They didn't bring, I mean, from the beginning they haven't brought anything to the table, but even today for trial, we have all this talk about what would it be like in a chaotic world if people followed the law. That's what I hear when I hear him say that. Because it's the wrong question, Your Honor. The question of what would happen if we properly apply the law to the regulated activity and do it according to what the law actually says. People might speed, people might go too fast, people might get hurt, and yes, they might. And they should be in trouble for that. But it's not through this. This is not the avenue for it. It would be through reckless endangerment, through something else. There's penal code provisions for that. And if we need to, we the people can go to the legislature and add something new in a world of chaos. But that's the wrong question. We can't ask what would happen if the law were followed. We have to just follow the law. And if there's some awkward or problematic result from that, we can fix that. Or these officers, like this peace officer over here earlier, he can get in somebody's face and say, look, that is reckless endangerment. I'm writing you up right now, or I'm taking you to the magistrate right now. He can do that, and should, if there would be a problem like that. I wasn't doing that. I was being safe. And as you heard from him that there was no rebuttal of 64 miles an hour. It's irrelevant. The speed signs here are have a very clear
Suggestive only.
audience. It's commercial activity. It's not me. So I'm also didn't rebut whether or not I had tuna steaks in my hand when I went down the fish aisle. It doesn't need to be rebutted. It's not relevant here. It hasn't been a part of any kind of offense. They're talking about prima facie this and that. There should be a very obvious answer here to whether or not I was reasonable and prudent under the circumstances then existing.
But I have the key.
When you look at the rest of the elements and you say there had to be a collision, and the reason for the collision had to be that I couldn't control my speed because I was going too fast. I was going too fast. I had a collision. The collision was with a pedestrian or another vehicle. Those didn't happen, and they're just kind of avoiding it, conveniently skirting around it to try to say what they think is reasonable and prudent based on prima facie of something that doesn't apply to me. It applies to those commercial. It specifically says. It's not whether I feel like it should apply.
We already debunked that, as we all know.
To me. I think Mr. Thomas and Mr. Sawyer would both like to categorize it as whether I'm kind of a rebel or I kind of want to do my own thing, and that's not it at all. I'm wanting us as a people, as a community, as all of us, to follow the law as it's written. And I can see what's written. It says specifically speed signs are for these commercial activities, these truckers, these semi-trailers, and that's not me. They failed to prove their case in a number of ways here at trial, but also I still have to go back to the fact that jurisdiction hasn't been established, and this is a baseless call.
Jurisdiction hasn't even been established. The absurdity of it all. This guy.
Cause of action from people that are not authorized to bring it, and they didn't bring any paperwork to start the case and all of that. So those are still outstanding, even though the motions have been denied and due process has been denied and all that. Even here, within the limits of just today's trial, they failed to make their case. They didn't bring all the elements up. They certainly don't have enough facts to go to them, and if they did, they wouldn't be admissible because no facts were alleged. Your Honor, everybody knows the Four Corners Doctrine. Even law school dropouts know the Four Corners Doctrine. You put some
Why are you citing contract law?
Document out there, you say, this is my pleading. You say, this is what I'm starting with. I'm starting a court case. Here's the problem, and you lay out the problem. You can't go off and start talking about other things. You can only prove what's been pled, and they haven't done that, Your Honor. They're talking about everything else. Oh, the world would be in chaos. Oh, can you imagine what Reagan County would be like? And it's totally irrelevant. They don't get to just invent a dystopian world in their mind and use that as their argument, because it's irrelevant. What is relevant is, does this transportation code apply? It hasn't been shown to apply. And do the elements match some kind of facts that have been brought up and have been admitted into evidence here? And they haven't. All the elements aren't even being listed here, and the facts that are produced are not admissible or don't check every box on there. So the state has failed to prove their case.
Thank you, Mr. Mr. Thomas, do you have a rebuttal?
I think Mr. Sawyer does, Your Honor.
Mr. Sawyer.
Yes,
Sorry, I got so used to calling on Mr. Thomas.
That's all right.
All right. I actually do appreciate the district attorney's response here.
Judge, we just listened to a lot of ranting. None of it really addressed the facts of the case, which is what we're here to decide. I'm sure it's probably popular in Reddit chat rooms for other audiences.
I just called him out as a Redditor.
What we're here to decide is whether or not was traveling in Wood County above the posted speed limit. That's it. We saw a video. We heard testimony. I was operating a vehicle, U.S. Highway 80, Mineola, Texas, Wood County. He was going 64 miles an hour in a posted 50-mile-an-hour zone. That's it. That's all we have to prove our case. It's overwhelming. Send it. Find him guilty. Fine him $99. That's all we're asking for.
All right, thank you, Mr. Sawyer.
Your Honor, may I speak to that?
You don't get a chance for a rebuttal. If you want to make a real quick statement, that's fine, but not a 2-minute statement.
Okay.
Real fast.
Just highlight that his whole case rests on the video. It seems like he's pointing at the video to say, we saw him operating a motor vehicle. Those are special terms. And we don't see any 50-mile-an-hour sign, or we don't see any 64 activity on the video.
All right, thank you.
Not there.
I feel like everybody had a chance to be heard today. Everybody got a chance to say everything they wanted. We've been in this courtroom since just a little after 9. It's almost 1. So I hope everybody at least feels like they had a chance to be heard. I'm not a law school dropout, but I do understand the four corners doctrine. I never went to law school. I've got a business degree from Texas Tech, and
yeah, if he had a business degree, then yes, I would expect him to know the four corners rule because it's a contract. Because it's a contract principle.
I don't know if there are any Texas Tech fans in here. You went to Tech. We beat OU this week, Saturday. So it was.
And of course, because this is Texas, we gotta interject college football because this is Texas.
It was a good weekend. So I probably should have gone to law school, but I didn't. And I graduated Texas Tech a long time ago, 25 years ago. No, not quite 25 years ago. I probably don't look like I'm that. I'm probably older than Mr. Sawyer though. I too respect. I think the U.S. Constitution is probably the greatest document that's ever been written. So I love the U.S. Constitution just like you do. I think that there might be some ways that you have misinterpreted some things that are written in there, but that's just my opinion, and you are certainly entitled to your opinion. You know, I have ruled against cops. I was a cop for a long time. I've ruled.
Now note that that the judge is actually not an attorney. He has a business degree and he was a former law enforcement officer, which, I mean, and in many jurisdictions that still exists that non-attorneys can serve as judges, but it's usually reserved for like remote areas in the United States. And last night when I last checked, Wood County has a total population of 45,000, which is pretty small. It's not large.
I found people not guilty. Go ask the cops, the deputies, the troopers, the city cops in Rains County. When I do my arraignments and I do my probable cause, I hold them to a higher standard than I hold you or you're just a citizen, because I feel like that's what we should do. But I certainly appreciate their what they do. Mr. Nichols, Trooper Nichols, would have been the same guy that would have pulled you out of that vehicle had you rolled off the side of the road or been in an accident, your vehicle caught on fire or whatever the case may be. He would have been the same one that had pulled you out of that vehicle and saved your life. So, you know, I do have a high respect for what he does and what these officers and deputies do, but I do hold them to a higher standard than I hold a citizen to. So, they're not always happy with me because we'll just leave it at that. So, but I think here, I mean, it's, you know, you don't.
Absolutely not, Alana. The only time where these judges would be involved would be municipal court cases and would involve misdemeanors like this, where, I would be very, very surprised if a non-attorney judge handled felony cases or cases where somebody's liberty is at stake.
To interpret, we don't get to write the law. I don't get to write the law. They don't get to write the law, and neither do you. That's what the state legislature does. Okay? And so when there's a posted speed limit of 50 miles an hour, you have to travel 50 miles per hour or less, or you're violating the transportation code. It's simple. Regardless of how you interpret certain definitions, the definition of a motor vehicle, the definition of transportation or whatever, you know, there are laws that we have to abide by in this county and in this state and in this country. Okay, you did violate the traffic code by traveling 64 miles an hour in a posted 50-mile-per-hour zone. And quite frankly, while you do have your right to be here today and have a trial over all this, I feel like you've made a mockery of the whole system. I respect these courtrooms, and I respect the system. I respect what the district attorney's office does. I respect what the cops do, and I respect you as a citizen, whether you're whatever your beliefs are. I respect that. Okay. However, you don't have the right to misinterpret the law and then violate the law and then use that as your defense, right? Because that's basically what you've done here. You violated the law. I could go on till 3 o'clock, but I'm not going to. I am going to find you guilty. $99 fine, $76 court cost for a total of $175. Okay?
Honestly, I feel like he deserves more.
Are you prepared to pay that today?
No.
And just so you know, let me say this. It's not about the $99. I don't think Wood County is worried about your $99 like you stated in your closing argument. I'm certainly not. I'm not a revenue guy, and I'm all about, it's more about public safety, okay? It's about public safety and making sure that we make that people comply with the laws that are set forth by the state of Texas, okay? It's not about revenue. So you made the comment earlier, I know they want my $99. That's really not what it's about. They've spent way more than $99.
They did. They spent a lot more than $99 just to try this case.
On this whole ordeal, okay? I promise you. So, I am finding you guilty, $99 fine, $76 court cost for a total of $175, okay?
I can't pay that.
Okay. Well, you'll have to bring that up with the clerks as far as when you can pay it, okay?
I don't have any income.
Okay.
Of course either he's lying or he doesn't have any income because he's a freaking again, I gotta be
Are there any questions?
Judge, we would have no objection to that being a payment plan or something worked out.
Okay. All right. And you can work that out with the clerks here. That's not something that I'll how do you want to address that?
He can come around to the front and he can fill out paperwork for a payment plan.
Okay. All right. We'll do that. Okay. All right. Are there any other questions?
Judge, I would ask the court to admonish Mr. that if he doesn't comply with payment of the fine, a warrant can be issued.
That's
and
right.
He can be arrested, and instead of paying the fine, he can sit it out in the county jail until the fine's paid.
That is.
Yeah. That's also another option. You can also pay the amount it costs to house you in jail and pay it off that way.
That's true. That is correct. You can, it's called time served if you want to go that route. It would basically be 2 days in the county jail. It's $150 a day. Since the fine's $175, it'd be $150 for the first day. You'd get the other $150, which would cover the other $25 for the second day. We don't split it up, so it'd be 2 days. Most people don't choose that route. But if you don't pay the fine, there would be a warrant issued. Okay. All right. Do you have any questions for me?
No.
Okay. Do you have any questions? Does the state have any questions?
There you go.
All right. Thank you all very much. Y'all have a good afternoon.
Thank you, Judge.
Could the gallery ask us, I know that it's adjourned, could the gallery ask a basic question?
Now, I think there's some, I think the whoever's talking now is some sycophant in the gallery. One of his freaking supporters, and he's gonna ask some asinine questions.
I don't know. Yeah, you can ask me. I don't know if I have
You don't even have to answer it, I just really want to kind of bring it up. The dispute about the Texas Code of Transportation defining commercial activity versus non-commercial activity, I never heard a mention anywhere that you guys disputed the authenticity of that being the definition of transportation. And the reason why I asked is because if this was ever appealed in a scenario like this, that would be the argument question at large, would it not? Is that legal or is it not legal? I'm just asking it.
Yeah, honestly, I'm pretty exhausted talking about this speeding ticket today, so we're adjourned. It's something to think about, I guess.
It's just a funny question to me, where that would lead, you know what I'm saying?
Yeah, I understand.
Yeah.
I understand. Y'all have a good afternoon.
Yeah, thank you.
Oh my God.
Yes, I think we can take this.
I don't even understand your question.
Yeah, I mean, we're just beating a dead horse.
So to serve a notice of appeal, would I serve it to this court or do I need to serve it to Raines?
No, it'd be here.
Okay.
Yeah, because when I'm sitting in this court, I'm serving Wood County.
Okay.
Yeah, Rains County has nothing to do with this.
Okay. Just making sure.
Yep.
Come on, let's go. Let's go, guys.
And that's it. We're all done. All right, I go ahead and go, Miss Mandy. We're it's all over. It's all over. Finally, found guilty. He has since filed an appeal as well as I think he's either continued with his lawsuit or filed another one against the judge or added the judge into the lawsuit. But he's already tried to file an appeal. And he's also trying to file a cert, which is stupid. But again, what are we expecting from this guy? But if actually, as a matter of fact, I think in his federal lawsuit, the magistrate has already issued its reported recommendations, which he's objected to because he thinks that only an Article 3 judge, aka the district judge, is permitted to issue findings, issue an opinion. I don't think that I think he's pretty sure he's wrong on that, but he hasn't posted the findings and recommendations yet. He said he would though, so once he does, I'll be sure to share it with you guys. But I'm gonna call it here. I know there are a bunch of other videos that I haven't seen and haven't talked about. I know Blandino has had another hearing. I need to steel myself for that one. And I also know that Code Blue Cam has some wild video involving Walmart and a false 911 call. We might get to that over the weekend, but I'm calling it here. Yeah, this exhausted me for sure. So, all right, have a good night, guys. Hope if I don't see you, have a great weekend. And yeah, take care of yourselves, and I'll see you next time. Adios.